Please. So I beg to mention for what urgent one motion matter. Urgency is in the sense that Lordship
What kind of matter was there?
is petition criminal under in special act.
It's a court number, I think,
The special act
18. Before 18, court number 18. Make a mention before court number 18.
Special act has been assigned to your Lordship.
You make a mention before court number 18, it may come before us.
May it please your Lordship, I beg to mention item number 19, with the consent of the petitioners, Lordship may kindly be pleased to adjourn the matter for the day.
19.
19.
You are for the
Number 2.
response number 2.
Appearing on behalf of my senior, Mr. Amit Goel.
Mr. E. Goel. For response number 2, read for an adjournment with the consent of the other side. So, was there any interim on and do you have any information? You are for the respondent. That's why just I'm asking you, do you have any information that there was any interim?
No, Lordship, no. I am for
No,
the petition.
you are for the petition.
Good.
It will be listed after 2 weeks.
Much.
May it please your Lordship.
Hmm.
I beg to mention item number 50, your Lordship.
50.
Supplementary list. I filed the additional affidavit, your Lordship, and
50 is the supplementary.
yes.
Yes, what is it? You have already
Yes.
filed the affidavit.
Additional affidavit, your Lordship, but it could not be taken with the main petition. Still, so matter may be taken at 2 p.m. Lordship, kindly.
It will obviously come at 2. Okay.
Okay, Lordship. Much obliged.
May please your Lordship. Item number 2, Lordship. List of appropriate benches.
Item number
2.
Yes, what you have said.
List of appropriate bench, Lordships.
Oh, acha, before appropriate. Why?
The same cases bill granted Lordship, the Mr. Legal Warfare. This can be with called.
No, Justice Kalita is available today. Available. Okay then. Okay. List before. List before appropriate bench. Next week, want to any date fixed?
Next week.
Next week. Okay. List before appropriate bench or next week.
May the Lordship. Lordship, item number 48, Lordship. This case, Lordship, though we are directed to take steps, but Lordship, we could not take this step, Lordship. That's why, Lordship, I may be allowed to take fresh steps. Upon the
48 had Mr. Ajad Ahmed, so and so. For the petitioner is submitted by him that inadvertently he could not take steps on the respondent. Accordingly, the petitioner is ever directed to take fresh steps on the respondents. It is the matter accordingly after 2 weeks, after 3 weeks.
Lordship, in this case, one thing, Lordship, this step should be taken through the registry of this court because this POCSO is there. So it should be.
It's a
Lordship.
POCSO matter.
Yes, Lordship.
Acha, to the judicial police station, routed to the office of the registry and the public prosecutor. After 3 weeks, it will be listed.
Okay, Lordship. Interim order is there, so that will come.
Interim order?
Yes, sir.
Will I soon record? Yes.
Item number 51, Lordship.
51. Yes.
Additional activity was filed as per your
Order
order
was
direction,
there.
Lordship. Yes.
Okay.
It's maybe
Call-
called
call.
from the registry, Lordship.
Okay, so we'll call you.
Lordship. All right.
May I please, Your Honor? Item number 35 and 36, Mano. Up to date case diary was called for in both the cases, Mano. I'm told it's not being received.
35 and
35 and
36.
36.
Both are AB.
Yes.
Yes, has come. Are you on interim here?
Yes, yes,
You are on interim.
yes.
She did not receive, issue reminder. Interim be continued till next date of listing, when it can be listed board.
23/4.
23/4. Your interim will be extended up to 23.
Another prayer, Mano, it should go to the appropriate bench, Mano. In fact, Mano, this was being considered by the my Lord Justice Middle Kolita man. My Lord,
Okay, list, attach only 10/3/20. No, CDB issue reminder corridor. Then we are not issuing reminder and all, just list before.
When the matter will be listed, my lord. Matter may be come up before the my lord.
Yes, yes.
Content the-
Yes, 23/4 corridor.
Lordship,
And if it comes here, we will
Yes.
list it.
Lordship. May I please, item number 34. Kindly adjourn the matter for 34.
34. Yes, 34. What is the position, Burba? Okay, it's the, what kind of case? NDPS?
NDPS, commercial quantities there.
You listed after 2 weeks then? List after 2 weeks.
Must of less.
May I please, your lordship?
Any request for it? Also.
May I please, your lordship? Item number 23 may be taken at 2 PM, your lordship. Admission matter, your lordship.
No, you cannot say. We cannot say. I'll just mark it, but I don't know. The other matters are there. It may not reach. Otherwise, I have marked it.
Means after 2 also it will be.
I have marked it. If it reaches, then definitely.
Yes, 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 it's lovely.
May I please, your lordship? Lordship, I beg to mention for listing a DA, but hearing Pulam minor, my lord, what happened?
What nature
What
of
happened,
case?
my lord? Is
Just
suppose-
no. What nature of case?
for a POCSO, my lord.
You make a mention before court number 3, no? Court number 3. Make a mention before court number 3,
Well-
it may be listed before this court.
I'm obliged.
May I please, Lordship? I would like to mention item number 18.
1/8.
Yes.
Yes.
Actually, the engaged counsel BK is not well, so matter may be
BK Das
taken
is
up.
not keeping well.
Yeah.
Mr.
matter may be
BK Das
taken up.
is not keeping well. Have you informed the other side? He was,
Yes, taken up.
Mr. NK Das is also there, correspondent number 2. Have you informed him
Yeah, we taken that.
with the consent of the respondent side? The learned counsel, Mr. So appearing on behalf of Mr. BK Das paid for an adjournment, stating that he is not keeping well. List accordingly after 2 weeks will do. List after 2 weeks.
Yes.
Lordship, I beg to mention item number 7, your lordship. Item number 7, on the last occasion, your lordship, we missed to take the steps, your lordship. So kindly, I pray for you to get an opportunity to take the steps again, your lordship. Upon respond number 2, your lordship.
Item number 7, your Mr.
And Millie, your lordship.
Hard Mr. N. Millie, the learned counsel for the petitioner, and it is submitted that inadvertently the steps could not be taken on the respondent number 2 on the last occasion. Accordingly, the case together full stop. Considering the submission made by learned counsel for the petitioner, he is the list he issue notice corridor. It's a what kind of case?
Criminal petition, your lordship.
No, criminal petition.
NDPS, your lordship.
NDPS.
Quashing the judgment, your lordship.
Washing for the judgment.
Yes, your lordship.
Who is the respondent then?
Respondent, your lordship.
State or otherwise?
State, your lordship.
Only state.
Only state is mentioned, your lordship. But according to office note, your respondent number 2 is written, your lordship.
Private respondents are also there.
Oh.
Okay.
Highly get
List
back.
after 2 weeks. It's 3 weeks going to list after 3 weeks.
Yeah, please, your lordship. Lordship, item number 6, lordship, would like to avail video conference, lordship. Lordship, the leading counsel who is in this matter, lordship, he has some difficulty today traveling from Patna, lordship. You would like to go for VC, lordship. We've already given the details to the court master. Why?
VC is for inconvenient for us, in fact. Because sometimes it happens that the voice cracks are there, sometimes internet connection drops. So why he could not
Understood, your
come?
lordship.
Why could
Lordship,
you
due
come?
to some personal difficulty, lordship.
Ask him to come on a next week any date then.
Lordship.
How long he is in custody, your petitioner?
Lordship, almost 2 years, lordship.
Huh?
Almost 2 years, lordship.
It's a NDPS matter.
That's the urgency, lordship.
It's not urgency.
What's my
He's a
time?
charge sheeted case, isn't it?
Yes, lordship.
Charge sheeted case, he is under custody.
Yes,
I can understand. 2 years is a long period. That is understood. But let him come personally. Hearing from here we feel convenient because from through VC, that's why some of the cases which we have taken out, we are bring out from other outlining benches. Just we are taking here as physical presence.
And this lordship, just for today, if your lordship may consider this. Just
What today?
Just for today, Lordship, the VC.
Today, the entire hearing will be there. What today? It's a motion matter.
Yes, sir.
What to do, Mr. Burwa? You are appearing here, the PP Assam, na? That's what we find some inconvenience. We are part in our part, in fact. Because in a motion stage, we do not want to hear because it's a NDPS matter. To obviously order without perusing the case record, there may not be, I don't know, there may be a case, that is different thing. Otherwise, without perusal of the case record and all the case diary, may not be a case also for bail. Yes, what to do? Allow? Okay then. Okay, we'll see to it.
Highly obliged.
Okay, if there is 30th, Lordship, 30th January. Lordship.
Interim is there. Okay then. Interim be at a item number 48, I think. Interim be continued till next date of listing. Okay, we are
Okay.
May I please, your Lordship? Lordship, I beg to mention item number 2122. For adjournment, Lordship, MSG Borgha is not well today.
D. Borgohan. His MSD Borgohan is not available. 21 and 22. These are connected, na?
Yes.
21 and 22. Reasons to say MSD Borgohan is personal inconvenience. She could not appear. 21 and 22. It will be adjourned for 2 weeks.
There is item 1 promotion.
So we have
Yes.
We have checked the record, my lord. The questions were put, but it was not reduced in writing by. This matter, my lord. Your lordship earlier rejected, saying that you come after examination of the victim and the informant. So accordingly, my lord, victim and informant were examined. And punishment is section 8 of POCSO Act, my lord. Proceeding is going on. Punishment is 3 years. And
Okay, you have
total-
annexed the
Yes, annexed, my lord.
evidence
Yes, ma'am.
where it is.
Page 34 is the victim.
34 is the victim.
And page 36 is the informant.
My lord, this is a POCSO
Oh, it's
matter.
a
My lord,
POCSO.
notices to
Oh,
my
oh,
lord.
yes, yes.
My humble submission, my lord. This is 3 years imprisonment. Today is 1 year, 4 months, 20
It
days.
is already in there.
On my, so earlier, my lord, I have accused your lordship.
Yes, have you provided the proper address? If it is then we try to fix it on before BU also.
My humble submission, my lord, at this stage, earlier your lordship heard this matter. Even both the victim also. The order, there is reflection in this order.
Now this is a
Kindly see the earlier order.
now this is the position of the presently High Court that we have to issue notice. What to do, see. At this stage, every stage, that is the problem. Otherwise, I was just perusing your record. In fact, as from your considering your submission, in fact. Before BU give a deeper training. It is from which case? Karimganj. Just take one chance. You just issue notice. On the next day, if he or she doesn't appear, suppose, then we'll immediately through an amicus, matter will be heard.
Even my lord, in earlier case also, they did not appear. Amicus curiae was appointed. So my lord, today also amicus curiae may be appointed because considering his their earlier approach, my lord, earlier conduct, they
He
did not appear.
appear.
They did not appear. Amicus curiae was appointed, and matter was heard thereafter. So my lord, today itself amicus curiae may be
Okay,
appointed.
okay, we'll see.
My lord,
Pardon,
because
Mr.
of
HR
book of my lord, this is a mandatory, my lord, because it is a new petition, my lord.
Since the contract is there,
My lord.
It's a mandatory, I think. Okay, our Mr. HR Sodri, Dynamic Counsel for the petition. And But if she remain, if she represented by the amicus, then sub purpose will serve, I think.
Well, that may be, but only the thing is that a bail is pending. That is what I understand is that is the meaning of serving a notice.
Yes.
That the
Okay,
victim
then.
should aware
Heard
about
Mr.
the fact.
HR Suri, Dilani Counsel for the petition, and also heard Mr. Kebosha, Dilanet additional PP appearing on behalf of state respondent. Issue notice corridor. Further, considering the submission made by Dilanet Counsel for the petitioner, amicus may be appointed on the next date of listing if this service return unserved. And list accordingly when it can be listed. Then.
Well, it's sorted, my lord. Because, my lord, it is routed through the office of the PP. In my learned friend take the steps.
It office of the registry, to the jurisdiction police station or to the office of the registry and the public prosecutor. But however, there has to be one week or.
My lord, then, my lord, is allow also to send that email, through scan copy in the email to the concerned police station. We will send that way also, my lord.
How?
My lord, one is a physical copy will be sent from the office. If my lord in the order direct us to send another scan copy of that through the email to the concerned police station.
Scan copy of the notice.
Yes, my lord. Then
Further, the
along with the physical copy.
further the additional PP oblique prosecution is also hereby asked to. Additional PP is hereby asked to send the notice through email to the concerned police station. The petitioner will take steps within 2-3 days. List accordingly when it can be listed then.
On my lord, on 3rd of April.
Third is not possible.
Or
7th of April, my lord. 7th of
then maybe 8th of April.
8th of
April.
April.
Okay.
Okay, 8th of April, my lord.
Okay.
My lord, may kindly provide a copy of the order to me. For
Yes,
further.
yes.
Yes, ma'am.
That will leave it with you. Also provide a copy of the order to the learned edition copy for onward transmission. But to do the needful. To do the needful.
Item 3.
May I please, Lordship? My lord, the petitioner, if you lordship, was arrested on 19/11/2024, and the case is charge sheeted. And the victim 19/11, 4 months, 6 days. Trial is going on
2020.
2024.
Four.
4 months, 6 days, my lord. My lord, victim, informant, other witness, my lord, were examined, my lord. I have annexed, my lord. The allegation is 75 and to BNS only sexual harassment. There is no eyewitness, my lord. And day after tomorrow is the next date. And
We have not made the party.
my lord, the petitioners
75 to
75. Sexual harassment, my lord. There is no eyewitness, only task.
No, we are not on that.
Lordship may kindly see page number 8, my lord. FIR.
No, we are not going to see.
My humble submission is that the petitioner will appear each and every day till disposal of the trial, my lord. And the trial is going on, day after tomorrow is the next day, 26. So, my lord, lordship may allow the petitioner to remain present in each and every date, and lordship may dispose of, if you lordship desires, my lord. Humble submission before lordship. My lord, 4 months, 6 days is over, my lord. I have annexed everything, my lord. Charge sheet, PW1, PW2, PW3, and a bail rejection order of the trial, my lord. And I have seen the depositions statement, my lord. There is no eyewitness, my lord. Only everybody is saying that incident was hard, my lord. And the only allegation is touch, my lord. Nothing else, my lord.
1, 2, and 3 are not the victim,
My lord,
not the victim. No?
my lord,
Is there
page
victim?
number 20,
Two is my lord,
PW2, page number 24, my lord.
Okay, PW2 is the victim.
my lord.
My lord. Page number 24. Susmita Biswas.
She is a teacher by profession.
Teacher by profession. While she was returning to her home, my lord, on the road, my lord, on the
with a
daylight,
teacher, such kind of
in a
things are-
broad daylight, my lord, the time of occurrence is 1 p.m., my lord.
No, whatever, with a teacher, he is doing these things.
My lord.
With a teacher,
No, my lord, incident was not taken place actually. Different, different thing, my lord. On
there
a
are
day broad
sufficient
light, in a
incrimination
day
against
broad
you.
light, my lord, on 1
There are
p.m., my lord.
sufficient incrimination against you.
My lord, in the broad daylight, my lord.
Why are
in
you
a
saying
public
that no
place.
eyewitness, no eyewitness? If a victim is there only,
Victim was there only
then why are you
because a
saying no
public place.
eyewitness, no
My lord, that is
eyewitness?
not correct, my lord. Statement is not correct because the public place on the route. I stated in the FIR itself, my lord, on the route and what 1 p.m., my lord. It is very much
Yes,
unbelievable. Lordship, I have annexed the
Record
entire.
is required, my lord.
My lord, I have annexed the entire statement stated before the police, my lord. The copy is there, my lord. Other witnesses are also there, my lord. Only everybody is saying that we have heard he was made even cry, my lord.
Our
Lordship,
sole
everything.
testimony is sufficient.
So, my lord, yes,
sole
it is
testimony
sufficient.
is
It is sufficient.
sufficient.
But only sufficient is that I am not praying for, my lord, I am not, I just pray for bail because I will appear each and every day from outside, my lord. Since he is more than 4 months inside the jail, my lord, I will appear
Yes,
each and every
sir.
day,
Yes,
my
I
lord.
have heard you. Yes.
My lord, 6 numbers of PWs are there, my lord. Only 3 is examined, and my lord, that is my lord.
Rest
maybe
of IO.
my lord,
IO is there.
is my lord.
May pray, my lord, some witnesses may be examined. May I pass this, my lord?
So, my lord, only my lord, 5 numbers of independent witnesses, my lord. IO is only the witness number 6, my lord, PW 6, my lord.
You are Mr.
Yeah.
Heard Mr. A.Ali, the learned counsel for the petitioner, and also heard Mr. P. Busher, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. Next one, Mr. Ali, the learned counsel for the petition submitted in this regard that the accused was arrested in connection with this case on 19/11/2024. And since then, he is in custody for more than 4 months. In the meantime, the charge sheet is filed and 3 PWs already examined, including the informant and victim of this case. And as all the party witnesses are already been examined by the prosecution, though 2 other independent witnesses still yet to be examined. Accused, next question, the accused petitioner is a permanent resident of his address locality, and he will appear before the London trial court below on each and every date to be fixed by the court if he is granted with the privilege of bail. Next para, in this context, Mr. Busher, the learned additional PP submitted that there are sufficient incrementing materials in the evidence of the PWs. More so, 2 more independent witnesses are yet to be examined by the prosecution, and hence he raised objection and submitted that bail should not be considered at this stage. However, he insisted to call for the scan copy of the case report along with the case diary. Next para, hearing the submission made by learned counsel for both sides. It is seen that the case is sufficiently progressed and all 3 vital witnesses of the prosecution are already being examined and hence tampering or hampering with the evidence of the prosecution does not arise at this stage. In next further, considering this aspect of the case, vis-a-vis the length of detention already undergone by the accused petitioner, I find it a fit case to extend the privilege of bail to this one. So, where it is pending?
Well,
Pending where?
Pending, my lord, CJM Qatar, my lord. Pending in the court of
Satisfaction
session, sir.
Oh, yes,
And it will-
sessions.
bail bond will be submitted before the CJM.
The satisfaction of the, there is an additional or in before sessions?
Before session, the last day, my lord, yes.
Satisfaction of the sessions as queried. Okay, you are granted.
My, deeply obliged.
Item 4.
Mayor, please, your honor.
Yes.
This is a regular bail application, my lord. The petitioner, he was arrested, my lord, on 2/3/2025, my lord. The allegations in the FIR is like that, my lord. One Nomita Talukdar from Rangapara, she entered into an agreement for sale of some land with one Gauri Chaudhary, my lord. And thereafter, it is stated that Gauri Chaudhary took an amount of money from her and then she absconded and she was not to be found. And she did not refund the money. And my lord, she did not execute the sale deed also, my lord. That was the allegation. Thereafter, my lord, my petitioner, my lord, the accused petitioner, he was picked up saying that, my lord, he facilitated an agreement between one Urup Kumar Chaudhary and that Nomita Chaudhary, my lord. Whereas that Urup Kumar Chaudhary is not at any way, he has made any allegations anywhere that he has been cheated out of the this arrangement between the petitioner and that, my lord, Nomita Chaudhary, my lord, that Gauri Chaudhary. And now, my lord, on the basis of that allegation only, my lord, he has been put into bars. And my lord, in this allegation which has come up now for, my lord, before the police, my lord, there he is no way involved, my lord. Neither with the facilitation of that agreement between Gauri Chaudhary and Nomita Talukdar, or, my lord, in anywhere else. And your lordship will see that FIR had been filed, my lord, 1 year back. And it was registered only in the month of February 2025, my lord. The lordship finds the FIR at page 19, my lord. In the second paragraph, your lordship will find to the officer in charge police station dated 14/2/2024. And my lord, it was shown before the learned CJM on the right hand column, your lordship will find on 25/2/2025, my lord. And my lord, it was registered, my lord, if your lordship find to page number, my lord, 17, lordship will see this was registered on 25/2/2025, my lord. At page number 17 on the right hand side, my lord. And if your lordship, my lord, kindly comes to, my lord.
Case was registered.
Yes, my lord. Case was registered on 25/2/2025. Whereas FIR was filed on 14/2/2024. After 1 year, my lord. And my lord, in the forwarding report at page 52, your lordship will find, my lord.
Shows the initial part when it was received. FIR was when received.
My lord, FIR was received, my lord, at the Tezpur police station, my lord. That your lordship finds at page number 17, my lord. District Sunitpur, PS Tezpur, year 2025, FIR number 134 of 2025, dated 25/2/2025.
And the occurrences of
Occurrence
23.
Occurrence is on, my lord. No, my lord. Here kindly see the occurrence of the offense is 26/5/2023. So in occurrence, they say it is on 2023. FIR was filed sometime in the year, my lord, 2024, on 14th of February 2024. That your
No,
lordship
14th of
finds
February, that I don't know,
2024.
but
At page
in
19,
the FIR, obviously, it is written as 14/2/24.
my lord.
But it was FIR was received in the police station only on 26/5. Sorry, 20. 25/02/2025. It is received.
Maybe, my lord.
Because information received is there.
That signature appears, and here, my lord. There also, my lord. Received and registered has been shown as 25/2/2025.
Yes, obviously.
Yes.
Because FIR is received in the police station.
Maybe. my lord.
Obviously, FIR is
Maybe.
of 2024,
Maybe, my lord.
but same has been lodged or instituted. I don't know whether it
My
was
lord,
received
If
also.
I write a date as 2024, perhaps it will not be registered matter and received in 2025. The police will ask me.
No,
to
no,
correct
I'm
that.
not on that. The FIR was, I mean,
Given
placed before the,
here,
yes,
yes.
before the police station only on 25.
But they had it on 25.
Yes.
But that is what I said, my lord. Suppose, my lord, somebody brings an FIR to me dated 1 year back. Definitely, I'll ask him to correct the date, my lord, before seeing that. And there is no interpolation, kindly see, my lord. So by that, anyway, that is not the issue. my lord. The issue before your lordship now is that, my lord, if your lordship kindly comes to page number 52. Page number 52, that is the grounds of arrest, my lord. From the statement of Gauri Chaudhary, it is revealed that she and Virendra Dhada, that is the petitioner here, both made a conspiracy to sell land measuring 2 katha covered by lag number so and so, pata number so and so, situated at Devrigaon, Sunitpur to Rupjyoti Chaudhary fraudulently. During the accused Virendra Dhada, he himself stated that he had introduced Gauri Chaudhary and Rupjyoti Chaudhary for sale of land, and all the related works in connection of sale of land to Rupjyoti Chaudhary was done by him. Gauri Chaudhary received ₹5 lakhs from Rupjyoti Chaudhary, but Virendra Dhada had made agreement to ₹8 lakhs received during the time of agreement fraudulently. All the documents related to the sale of land has been seized from the possession of the accused Virendra Dhada, which revealed that without proper verification of the land, he and Gauri Chaudhary fraudulently sold the land to Rupjyoti Chaudhary. Virendra Dhada was the main middleman between Gauri Chaudhary and Rupjyoti Chaudhary. Now, this is a relation between my lord Rupjyoti Chaudhary and that Gauri Chaudhary, where she said that Virendra, this accused petitioner, he made certain facilities. But in respect to the FIR, which is now before your lordship, if your lordship kindly see, my lord, at page 19. May I read that, my lord? With reference to the subject cited above, I, below name and address and wife of a defense personnel, and hereby submit this petition concerning the land transaction involving 2 katha of land situated at village Devrigaon, village so and so, so and so, so and so. On May 26, 2023, my husband Vishal Kumar Shah, son of so and so, address so and so, entered into a notarized agreement by so and so with Messrs. Gauri Chaudhary, daughter of late Sudhir Chaudhary, for the purchase of aforesaid land for a total consideration of so and so, of which he has already paid 18 lakhs through check and online transaction. However, it has come to his attention, Mr. Orup Khoikia, son of late Mohendranath Khoikia, residing at Muratetli, has lodged an objection regarding the very same land. This information was conveyed to me and my husband through reliable source. Despite Mr. Khoikia not being the patador of the land in question, his objection is significantly hindering my husband's ability to obtain necessary permission from the concerned authority, thereby obstructing the registration of the property in my husband's name. I hereby submit this representation on behalf of my husband, who is currently serving as a defense personnel. It has come to my attention that an individual named Gauri Chaudhary has allegedly engaged in fraudulent activities where she has concealed essential materials and relevant facts from my husband, resulting in an unlawful transaction of ₹18 lakhs from him under the pretext of a land registration. Despite our repeated attempts to seek recourse to Kasarigam Police Outpost and the Tesco Circle Officer, we have yet to receive any justice or redressal for his grievance. Gauri Chaudhary has not only failed to provide the promised land from Orup Khoikia, but has also evaded the payment of the amount taken from my husband. Gauri Chaudhary promised through legal notice dated so and so, but she will clear all the dues till January, along with compensation of ₹6 lakhs. Given on that my husband's duties often render him unavailable, I am compelled to take this matter into my own hands. I have so and so now.
Yes, I can understand. During
Now
at the
that-
time of filing FIR, it was not within the knowledge of the informant regarding the fraudulent acts paid by your petitioner. So we call for the case record, I think. Case diary.
Lordship may consider that only, my lord, I have completed 22 days in custody. My lord.
whatever.
These are all, my lord, 60 days, my lord.
Yes,
So
60
then,
days.
my lord, lordship may kindly fix it on 27th, my lord.
It's not more matters have been fixed. No, Despot is different thing. Fixed matters are there. 25, 26 already fixed matters are here.
Understand, my lord. Considering, because there is one more aspect I have taken up, my lord, here.
When it can. Second of April.
I'm deployed.
City Council. Okay.
Item 5.
It may please your lordship. Your lordship, the matter pertains to NDPS, your lordship. But there's a
Charge
catch.
sheeted one?
Indeed, your lordship. The charge sheet has been filed, your lordship. First, if I may take your lordship, as per the events of the case, your lordship. Your lordship.
No, just tell us. It's a
Charge sheeted one.
one.
Indeed, your lordship. It is commercial quantity, madam.
It's a commercial quantity, so obviously perusal will be required, I think.
The perusal may be required, but there is an aspect that your lordship may allow me to speak on it. Your lordship, there was an unnamed, unmanned, unnumbered scooty, your lordship, where the possession was recovered. We had a different vehicle and we were not found in the spot, your lordship. If that has been
Definitely.
so that appraisal may be done and the case records may be called for. They have been languishing in jail for now 385 days, your lordship. So, your lordship, in that
More
regard,
than a year.
more than a year, your lordship, and they are the sole earners, your lordship, and they have come through legal aid, your lordship. So that is why they have no other sources. That is what the council wants to play before your lordship.
So their scooty doesn't belong to you.
It does not. There's a different vehicle which was seized also, your lordship, which I may take through your on page number 28. The seizure list is there. That belongs to me, and I was in that vehicle, your lordship. We both were in that vehicle. I was actually a teacher, your lordship. I'm a teacher in a school, your lordship, which is also there in page 40. I have attached. I've been appointed as Hindi teacher, your lordship, and I've continued that job, even though the madrasas have now been converted into LP schools there. Your lordship, in that regard, your lordship, since we are the sole bread earners, we have nothing, your lordship, in that regard, and we have been languishing in jail for over a year now. Your lordship, that was and we have come through legal aid. And that is why, your lordship, the prayer is of the utmost importance, your lordship. And the matter is now placed before the special judge, your lordship. It has been called for evidence as well as production for the past 4 days, your lordship. For the past 4 dates, your lordship. The next date is tomorrow, your lordship. That is why the matter has been placed.
Yes, when can be fixed.
Yeah, it is a request.
No, it will be required.
Madam,
Scan copy along with the case diary, we are calling it.
Yes.
It will be fixed when you can give
A date fixed.
9th. 9th of
Much obliged,
April.
your lordship.
Item 6.
Yes, it is already linked. What I don't know.
6.
Yes, you are not audible. You are not audible. You are not audible.
Just a minute. My lord, this is a matter of NDPS Act. The FIR has been filed under section 20B2C, 25 and 29.
22B and
20B2C oblique section 25, section 29, NDPS Act.
Commercial. 20B2C.
C is also there. 25, 29. 25 is also there, no?
Yes, my lord. 25 and 29.
Yes. Then.
And the total recovery is of 51.35 cases, my lord. The petitioner is the driver of the vehicle, and he is in custody since 10 February 24. It's almost 13 months, my lord. And the trial has not been started yet.
The charge has already been framed or yet not yet?
Charge has been framed,
Charge.
my lord. Yes.
Otherwise, is he related to that offense? Is
He was the driver of the vehicle from which the
contraband was recovered?
contraband was recovered. Yes, my lord.
Yes, for question.
When I call for the LCI along with the case diary. It was commercial quantity, my lord, and he is the driver from where the contraband was recovered.
And obviously, your petitioner is behind the bar since last 13 months. It is quite a considerable period. He isn't behind the bar, but the question is that it's a commercial quantity matter. So we have to call for the case record along with the case diary. We'll see to it. And apart from this present status report of the case. What is it?
Obliged, ma'am.
When it can be called from? After Bihu. After Bihu will do. It has to come from which place?
Karimganj district.
Karimganj.
Yes, my lord.
So in listing it, there was a vacation for Bihu. So after Bihu, we are listing it on 22nd of April. Will do?
Yes, my lord.
22nd of April. Okay. Call for the case
Obliged,
record along with the case diary. And also the present status of the case. List accordingly on 22. Okay.
Item 50.
50.
Item 8.
Yes.
May I please, Lordship? Lordship, the maintenance case has been filed by my legally married wife at Dibrugarh. And I have stated some grounds why this case should be transferred from Dibrugarh to Mankachar. It is pertinent to mention here that that I am a resident of Meghalaya, that is Mahendraganj, but I am not seeking that transferring to Meghalaya because it is not possible. So marriage was solemnized at Mankachar, South Salmara district, my lord, South Salmara, Mankachar, at the residence of the father-in-law of the petitioner. Subsequently, due to my lord some false allegations and so.
By the way, the respondent is the resident of Dibrugarh.
No, actually, my lord, the residence of the father-in-law, originally he resides at Mankachar and marriage was solemnized there. But he has some business set up at Dibrugarh. So it is a secondary abode, my lord, of my father-in-law. So due to my lord differences and only for the sake of causing harassment on the petitioner, they have filed that maintenance case at Dibrugarh. But it is totally jurisdictional aspect is, if it is considered, then it will be my lord South Salmara, Mankachar. This is the one aspect. Number two, that I am suffering from, I have medical document I have annexed, page 63, that, and I am seriously suffering from appendicitis. It is a recurrent appendicitis as well as fatty liver. So to visit to a long distance from Meghalaya to Dibrugarh, I'm not saying to transfer it to Meghalaya, I'm saying a convenient place where the marriage was solemnized at Mankachar.
But in Mankachar, whether anyone is staying now from the
yes, my father-in-law's residence is there. He is just going there, and here it is my lord for due to business purpose.
But presently
yes.
They are staying at Dibrugarh.
Yes, Dibrugarh. He is staying. Dibrugarh.
Now you see from Dibrugarh to Silchar. For lady, she has to come from Dibrugarh to Silchar.
My lord.
Then?
No, my lord, my humble submission will be that since marriage was solemnized here at Mankachar and during the peaceful conjugal life, they initially resided at Meghalaya, Mahendraganj. Thereafter,
For some time, they resided at the father-in-law house in Mankachar. Thereafter, my wife shifted to Dibrugarh for a while, and now is I have
Now,
filed
see, at best, we can issue notice here at present.
my lord, in the meantime proceeding maybe.
No,
the
what is stage of the proceeding at present?
proceeding it is for WS.
So
now.
you file your WS through your
I have
counsel,
appeared before that.
through your counsel, file your WS. For filing WS, may not be required, your presence may not be necessary.
My lord,
May not be necessary
well,
because
another-
it's a maintenance case. We cannot stay with the maintenance.
my lord,
It's not our.
another aspect, the petition I have annexed with this petition. My wife is having sufficient
Income.
resources to, yes, I have, they have already stated here.
The dues
So
with the
there is
matters
no
of, we are not on that. We are simply on the transfer petition.
Yes,
For your convenience, you have submitted that it may be transferred. We are not on merit.
Yes.
Merit, we are not going to see. Simply whether it will be convenient for you or her if it is transferred to Mankachar. That is the only issue.
it is
The
very
rest we are
much-
not going to. But the now question is there for our part. We are not specially this court, we are not staying any maintenance matter. So we are issuing notice. Now that's it also, it's a fixed cases fixed over WS only.
WS.
Through your NDPS council, you can file your WS. There's nothing, no bar at all. And you can pray for a time. By the time we are calling for the case record and the scan copy of the case record, we are issuing notice also. We will listing it after, say immediately after BO only. Your next date is when?
It is 28th of this month.
28th. So
Yes.
obviously it will be a
Yes.
date after BO only.
My
So
lord,
we are listing it after.
Another aspect I must submit that I am a very incomeless person. I have no income due to my recurrent.
So why you got married her? Why you married her?
My lord, this is the.
So you don't have
happenings.
any income, you have
This is
no
the-
income, so
this
she
is
is
the
the money
incident that,
lady.
Yeah, initially I had a full.
Now you have, second time you have married? Now?
No, it is a second time, but.
It's the second marriage.
Yes.
First marriage, wife is?
Wife also a second time, she also divorced her first husband.
This is her second marriage, you're also second
Yes.
marriage. No, it's okay then. But what about your first wife? Where is she? You're not maintaining her now.
That marriage was actually not solemnized in a formal.
So this
manner.
is your
It was
first-
just engaged.
You're going to second wife or third wife you're going to marry?
No.
Then.
There is no plan. There is no plan.
So that is the issue, what to do.
So earlier I
Having
had
nothing,
income.
also
I
you
had
got
sufficient
married.
income. I had a footwear shop, but that was sold out due
Closed.
to persuasion of my wife.
Maybe you
And
may be in
all
a
money was
trouble.
invested in the business.
Now see,
of
we are not on merit, in fact, we are not
Yes.
going to see the merit, so see, issue notice corrigible. Also call for the scan copy of the LCR. List according, we are even, in spite, we are giving a date also. And a date give, 25/4, we are listing it on 25. You take steps so that she can appear and matter may be heard. And it will be at the admission stage, if it is an admission stage, we may be disposed of in the admission column, it's a small matter.
Madam. Covered.
Item 9.
Your
Yes.
lordship, my senior, he is out of station for his.
Your I was there, na? I is already disposed of, so it is now registered, in fact, criminal petition. So revision petition, most probably, there was a delay, I think. I'm not sure, but maybe
Yes.
delay that has already been condoned, I think.
I have found condemnation of delay, madam. It's a limitation act.
That has
Rather than
already been
dispose of. So what my lord I have found is that they have to take steps, madam, because maintenance matter against ex parte order.
You want to submit anything or just you want to make an adjournment here? The request for it, the request made by so and so. Listing matter accordingly after we're listing it after 1 week.
Item 10.
bail application. In fact, my second application. Earlier, it was registered as a crime branch case. Subsequently, it was transferred to Silsor and registered as Silsor PS case. Your lordship's order at page 23. Prior to that, I'm coming to the FIR, my lord. At page 14. All the accused persons, 7 except the present petitioner, are from the Bihar. There is an allegation that petitioner, along with another, introduced the informant to some other person for supplying some rice melon. So petitioner and the other accused number 2 introduced them. Accordingly, they have transferred money to the account of those persons, not to my account. And subsequently, my lord, what happened? All the accounts were seized. Money has been recovered. Money has been seized. Account has been frozen. And
Money recovered.
Money has been recovered at page 43, my lord, and Zimma also given to the informant. Of course, my lord, amount is high, my lord. It is almost around 10 crores. And my lord, the Zimma has been given more than 9 crores, my lord. Already he has taken Zimma. And another development, my lord. One, there is some mutual understanding between one Asif Iqbal and the informant. So Asif Iqbal, my lord, taken the responsibility by executing a agreement, deed of acceptance. My petitioner, my lord, somehow able to collect that document at Annexure 3, page 26.
Page 26.
Yes, my lord. So he has taken the responsibility, and he is saying that the present petitioner along with the other accused petitioner has nothing to do. And paragraph 2, my lord.
This deed of acceptance has already been placed before the IO?
No, he cannot, my lord, because he is not on interim, my lord. So that is why.
No, through this person, Iqbal?
Iqbal, my lord, he is in Bihar, my lord. So, my lord,
Through him, it can be. It could have been, I think.
my lord. So, my lord, this Iqbal is not known to him, my lord. He somehow collected from the one friend of that informant. So whether Iqbal has submitted it or Iqbal is residing at Bihar and present case is registered at Silchar. So, my lord, I am, my lord, looking into the present, my lord, development. Earlier, my lord, case was registered in the month of February.
Otherwise also your deed of declaration or acceptance is an important document.
That is an important document. And another development is that all the, my lord, allegedly misappropriated document money has been given Zimma to the informant. And present petitioner account has never been frozen because no money was transferred to his account. His role was only that he introduced those persons to
He is the accused number 1.
Yes, madam. So he has introduced the informant to the accused persons and money transferred, and subsequently it was recovered. Earlier, order was passed in the month of April. So in between, now it is March 25. So these are the developments in between. So investigation has subsequently progressed, and I may be allowed to, if your lordship permits, some strict condition that he can produce that document before the IO, my lord. At best, he can be, used as a witness actually, because his evidence is very necessary. So I am, by my lord, limited prayer, my lord.
Yes.
My lord, he is a FIRNAM accused as stated, my lord. My lord, FIRNAM accused number 1, my lord, and earlier, my lord, that is rejected on 2/4/2024, my lord. And my lord, whenever my lord rejecting this prayer of the petitioner, my lord, elaborately, my lord, discuss after perusing the city. My lord, maybe a short date for the city because the huge transaction amount of about 10 crores, my lord.
Lordship kindly page 40.
Allegation is serious, my lord. Have a short date, my lord. Maybe call for
Kindly see the page 42, my lord.
Page
42. Order dated 13/12/24. So this is one amount. Paragraph 2, my lord. 7 crore 25 lakhs. This is one amount, and the next page 43, my lord. Paragraph 4. In view of the report of the additional SP
Police Headquarters, Silsar, and in view of the guidelines of Honorable Apex Court so-and-so, I deem it proper to direct the IO to expedite the investigation of the incident case and to do the needful to release the money seized in connection with the case to the petitioner, namely Abu Ahmed Mojumdar. He is the informant. After obtaining bank guarantee of the petitioner of equal amount of the seized money. And then next page, my lord. This is another amount, 1 crore 35 lakhs 62,000. This was the amount deposited in this money was not seized, but the account was frozen. Subsequently, it was released and money has been given Zimma to the informant. So, my submission almost all the money allegedly misappropriated has been recovered.
Yes. Okay, we call for the case record and case. And also, question is that obviously there is some development as you have stated.
Well,
money may be recovered or that has maybe given Jimma to the informant also. But that there's not, and your case will not be based on that record. But however, there is some sufficient progress may be there because I have passed the order almost 1 year prior to this order. So we have to peruse the case diary. Is there any requirement for your custodial interrogation or not? That has to be seen. So we have to call for the case diary. Yes, Bosha, when it can be.
My lord, maybe short date, my lord, from Kasar, but we will try our best to take it, my lord.
I am trying, my lord, at any condition, if my lord lordship permits, my lord, then he can produce that deed of acceptance.
Once rejected, we have already seen it. Second of April. No, there is a steep or short date.
8th of April, my lord. 8th of
Okay, 8th of April. It is from Kachar.
Kasar, my lord.
Okay, we're calling it again.
Problem.
Yes. City Central Corridors.
Item 11.
May I please?
Yes.
This will be bail application FIR at page 11 lordship.
Page 11.
11. It's a long FIR lordship type copy. Informant and the petitioners are the friend lordship. On the day of alleged occurrence lordship, they visited Guwahati for a specific purpose lordship. But due to some misunderstanding and quarrel amongst them lordship, instant FIR has been lost lordship. And most of the petition
How many? 5 numbers of petition?
5 numbers. One is an advocate by professional lordship, and 5 is
nowadays the cases against advocates are lost now. We are facing sin. Anyway, he is the advocate, and others are 2, 3, 4, 5.
all of them are friends lordship, informant and lordship. Lordship will not find any ingredient of robbery in the lordship, FIR lordship. Though the
Case is registered under which section?
309 and 351. 351 is available lordship, and 309 is non-bailable.
3093, no?
93 is non-bailable. Up to 10 years lordship.
So what the FIR says?
FIR says that he was forcefully brought to Guwahati and demanded some money from the informant lordship by the petitioners. And they threatened him with dire consequences lordship in lieu of money. We may be allowed to appear and record our statement lordship. In the meantime, lordship. Nothing that he paid any money or
person could not go even Hojai to file the FIR.
Is available in Huzai Lordship. His statement recorded. PS case registered in Huzai Lordship. After zero FIR.
But he filed the FIR before dispute.
Dispute immediately it was transferred to the registered as
No, no,
Huzai case.
I'm not on that, but
Lordship.
here the reason is
Reason is
explained, well explained,
Yes,
that
yes.
how why he could not file the FIR in Hojai.
Yeah, after recording his statement, it
Now
was released.
from his own house, he was taken, then kept in Guwahati, then demanded money, even threatened to kill. So these are there. It is not a case for, in fact, it is not a case for interim, I think. Yes,
Will
anything.
appear Lordship, otherwise.
My lord, he was taken, my lord, the person filed the FIR in this point, clearly stated, let us produce the CD, my lord. Yes, sir.
It is immediately transferred to Huzai Lordship, zero FIR registered.
Now
And his
investigation is from Hojai.
His statement was recorded, then registered Lordship. He is available, very much available in Huzai
Hojai.
Lordship. He is very much available.
It's not a case for interim, I think.
Some protection Lordship. Advocate is also implicated Lordship. Will appear and cooperate Lordship.
Yes, CD call for you. Yes, Bosha.
Will
My lord,
cooperate.
short date for a CD, madam.
We are already.
Well,
The
before-
dates before we have already almost 7 can be given. 7-4.
Item 12.
May I please your lordship?
Yes.
Lordship, this is a 482 BNS matter. Annexa 1, page 12 is the FIR.
Page 12.
Page 12 is the FIR.
Hmm.
Here the case of the informant is that after in the year 2020-2021, as per her, my lord, PMMY house was allotted in her name, but instead of giving her that house, the money was transferred and the house was allotted in the name of the petitioner. This is the case of the informant, my lord. And she has come to know about this said fact by looking at the documents at online, right?
No, but the house was initially in her name, allotted in her name.
Allotted in her name. The reason, my lord, I have annexed. My lord, may kindly be pleased to peruse Annexa 3, page 22. Annexa 3, page 22. Both the husband and wife has applied for this scheme. Annexa 3, page 22, last two numbers, names, my lord, last two names. Dilara Begum is the informant, my lord. Annexa 3, page 22. Last, second is Dilara Begum. And last is Abdul Khalik, the husband, my lord. Wife has applied in the name of father and mother. The husband has applied in his parents' name. House can be allotted only to Dilara Begum.
Dilara is the wife of Abdul. They
Abdul,
both of
yes.
them appeared. And whose parents?
Dilara is the informant, and she has applied in the name of her own father and own mother.
Oh, acha.
And the last name at Annexa 3, page 22, Abdul Khalik, which is also reflected through FIR also, my lord. Abdul Khalik is the husband. Abdul Khalik is the husband. He has applied in his parents' name. So house can be allotted only to one person of the family, not to husband, not to wife. So what was that? It was allotted in the name of Abdul Khalik, which I have also annexed in the documents, my lord. So,
Abdul Khalik had already been allotted.
already allotted, my lord. Annexer, I take your lordship to annexer, Annexa 1, page 18. Page 18. It is allotted already, Abdul Khalik. Rufon Mia, father name. Is already allotted, my lord. Already allotted.
But the
So the
allegation is
house-
that, yes, but
yes.
the allegation is that the name of it was allotted in the name of the petitioner and
It was allotted to another person whose name is Dilar Hussain, my lord. It is Dilar, Annexa 5 is the certificate of the Gaubura. This particular house is allotted in the name of Annexa 5 certificate by the Gaubura, and page 28 is the certificate that this was allotted, the PMY certificate that did not Dilara Hussain, Dilara Begum, but Dilara Hussain. It was allotted, my lord. Page 28, I have also annexed that document.
Page 28.
Page 28. Dilara Hussain, my lord. This is allotted. And which is certified and counter verified by Annexer 5, page 32. That is the certificate of the Gaubura.
Yes, Busha.
My lord, that is, my lord, in the FIR, my lord. That is in the vernacular part, my lord, page 15, my lord. But here, my lord, Zahar Kali, Dilara Khatun, they have stated as a Dilara Hussain, my lord. Zahar Kari, my lord, Dilara Khatun, within bracket, Urf Dilara Hussain, alias Dilara Hussain. So, my lord, and again, my lord,
Who is the husband? Dilara Hussain, husband's name is?
Dilara Khatun husband.
No, Dilara Hussain.
Dilara Hussain is a man, my lord. Already allotted.
Dilara man.
Yes, my lord. Annexer page 28. So because of that, they have written in that. How can an Hussain and Khatun, my lord, allies?
And my lord, here, my lord, in the
page 28.
Generally, see, Busha, generally the Muslim movement does not. Title is Hussain is.
Khatun, my lord, they're male.
Hussain may be there. I don't. I won't say it not be.
My lord, here, my lord, it is Dilbar Hussain. In the 33, page 33, Gambuha certificate.
Dilwar.
My lord, Aru Fotut Ullek Kora Byaktijoner Nam Dilwar Hussain.
Dilwar.
My lord, may kindly see the serial number also. They all villages have one serial number 1574771 that tallies with Udali Poschim Udali Gao Panchayat, my lord. Poschim Udali Gao Panchayat. And my lord, the husband of the informant, they belong to the Udali Gao Panchayat, which is also reflected in the document, and they have another serial number. So, my lord, what happened was that she was happy at her own home. She was getting everything. Through political, she came to know that there was some typographical error in the list. She went to online, took out the online documents and lodged this FIR without going through the office, without going through verification. So we have collected all the annexures and we have taken all the certificate also. And both belong to different Gao Panchayat also, my lord. Petitioner belongs to Poschim Udali Gao Panchayat. She belongs to Udali Gao Panchayat. They have different serial numbers also, my lord. So, my lord, here my submission is that, my lord, petitioner has not got that home. This was granted to one Dilar Hussain, my lord, which is verified by the Poschim Udali Gao Panchayat Gaubura. If there is, my lord, any material, my lord may reject the petition at any stage. At this stage, my lord, the ED is also near and prima facie the documents are also in my support, my lord. So I'm praying for a plan to interim to appear with all documents, my lord. She has verified through online without going to the office. Online, my lord is aware how the typographical errors are there. And my lord, one Khatum will never become Hussain. Elias Hussain, how can a Khatum become Hussain, my lord?
Nowadays, it can be, I think. Anyway, hard MS SG Borga, the learned counsel for the petition. And also hard Mr. K. Bush, the learned additional PP, appearing on behalf of state respondent. This is an application so and so in connection with so and so. Next, Mr. Akim, MS Borga, the learned counsel for the petition submitted in this regard. That if false with some false and concocted allegation, the present FIR has been lost against the accused. One accused petitioner. One accused. He is the what strength he is doing?
My lord, he is nowhere. He is the neighbor of Dilar Hussain, one who was allotted the house. So
But the allotment is done by the Gaon Panchayat and all, na?
My lord. He
So how Giyasuddin, who is he?
Because the geo photographs are taken, my lord. The photograph uploaded in the geo photograph belongs to the father of this petitioner. So that is why she thought. And the person whose house is allotted is the left side next house of the petitioner. I have stated also.
Person of this so and so. She is saying to the that this is both the informant and her husband applied for a house under which scheme? PMYAY scheme. PMAY, huh? PMAY. and the so-and-so scheme. And her husband, and with the so-and-so, and with two applications, she and her husband applied for houses for her parents, for their parents. Accordingly, considering the application filed by her husband, the house is already allotted. And from Pachim Udali, na? Pachim Udali, or
They are from Udali Gaon Panchayat.
and they are from Udali Gaon Panchayat, and the
Petitioner.
one Dilwar Hussain was allotted with house from and he is from Pachim
Udali Gaon.
Pachim Udali Gaon Panchayat, but without verifying without going to the office of the panchayat or without verifying any other documents, the present FIR has been lodged with some false allegations. More so, the Gambra has already certified that said Dilwar Hussain was allotted with a house from under PMAY scheme. Full stop. The present accused petitioner is no way connected in the alleged offense. However, he can, if he is granted with some interim protection, he may appear before the IO and can produce all the relevant documents which he has already collected in connection with this case. Next paragraph. Mr. Busher, the learned additional PP, submitted in this regard that the case diary will be required to know the actual fact of the case, and prima facie it is seen that there is a case against the present accused petitioner. Next paragraph. Considering okay, will be protected.
My lord.
Appear before the IO within 7 days.
My lord.
We are calling for the case diary when it can be fixed. But after due vacation, obviously after due vacation, 28/4 will.
Obliged, my lord. Highly obliged.
13.
Yes.
This is an application by two persons, petition number 1 already arrested. So I am not.
One is already arrested.
And so far as the petition number 2 is concerned, allegation is cow lifting, madam. And Lordship will be, my lord, Lordship will find at page 17. What is the allegation against the petition number 2? He is an imam and he is also a teacher in madrasa. He is doing all religious function. And now he is thought to be implicated as cow lifter. Lordship, kindly, may I read, my lord, that's relevant portion where PW2 was implicated.
Page number 17, my lord. Residents at Bihipuria by using the sole four-wheeler and taken the said cattle to the residence of Nazmul Hussain. During inquiry, it is also learned that they used to frequently do this business. They have other associates in Lakhimpur district, namely MD Rafiqul Haq of North Lakhimpur. This is the present petition of my lord.
The statement that they have got other associates, including one Rafiqul Haq, the petition number 2. And he is an imam, therefore prima facie it appears that, my lord, what is be given to my statement, that he is an imam, he is attached to madrasa, he is doing his, my lord, religious function, and under such circumstances, my lord, whether it is at this stage, my lord, without looking into the CD, when court may presume that he might not have been, my lord, involved. My lord, some protection be given because he is an imam, Lord, he is doing his religious function every day in masjid, my lord. And if, my lord, CD says something, my lord, against me, then Lordship may cancel my interim protection. And I am ready to abide by any condition, even to appear before the Manari for giving statement.
This is also registered under 3314305B.
Yes.
3174111.
Cruelty to animal. Prevention of cruelty to animal. And
No, that is the prevention. Other parts is BNS.
Yes, my other parts is BNS. I'm looking at your lordship, my lord. Now, whether he deserves to be, my lord, for some interim protection. Number of sections are my lord, inserted. 331(4), 305B, then 317(4), 111, 313 of BNS, and 11(a)(d)(e) of Prevention of Cruelty to Animal Act, read with section 13(1) of Assam Cattle Preservation Act 2021. Only, my lord, basis of implicating is the presumption they might have involved, and he is the associates of other cow lifter, my lord. Whether he is an associate or not associate, it requires some, my lord, investigation to that extent. And till that time, my lord, some protection will be given to him. I have stated, my lord, in my para 5 details about his status as imam and what sort of religious function he is discharging, my lord. People used to come to him because, Lord, so far I am told that, my lord, under their, my lord, religious practice, imam is to, my lord, do halal, and people used to come to him. And that might be one of the, my lord.
Halal will be there in the occasion only.
Halal occasional.
Halal
Normally, no, my lord, normally it happens.
Yes, Bosha.
My lord, here it is a police during a Naka sacking, my lord. They, my lord, seized one vehicle, my lord. That was, my lord, one 4-wheeler white color model Maruti Desire.
Why not present?
And my lord, from where, my lord, police, my lord, recovered one, my lord, cow, brown color cow. My lord, that was in the Swift Desire. And during the course of interrogation and investigation, they found that there is an excess, my lord, in entire Lakhimpur. And present petitioner is one of them, my lord. So, my lord, this is a, my lord, FIR filed by the police, my lord, the IC.
But the rest of these sections are there, that is 331, 335 are also there.
My lord.
So was there any seizure from his house? Was there any thing is there?
My lord, from his custody, that was not
Cruelty
covered,
attracts,
the
prevention of cruelty to animals, that is there, but otherwise?
Otherwise, he is not present at that time of occurrence, my lord.
And I have an
His presence is not there.
It was seized from a Swift Desire.
Yes, I have,
My lord, that was, my lord, that is, my lord, seized from another person, my lord. That is in the FIR, my lord.
Yes, obviously.
Yes,
It was
yes,
seized
ma'am.
from another person, but
Another
during
person.
interrogation, it has come
This
to the light
person
that
is not
these are
present at
they
the
are
time of
also
occurrence, my lord.
that said Imam is also there.
My lord.
But
Not
I have-
only along with other persons also.
I have annexed, my lord, a seizure list at page 18 onwards.
Your Imam is there. I mean, he is also associated.
According to them, my lord.
According to police, my lord, during inquiry, it is also learned that they used to frequently do business. They have other associates in Lakhimpur district, namely Muhammad Rafiqul Haq of North Lakhimpur, and his brother, namely Anar Sahil Intaz, and the elder brother of Nazmul Hussain, namely Nur Hussain, respectively. Here, my lord, a gang, the name of some people, a syndicate, their names are mentioned, my lord. My lord, that is my lord, in the first part, my lord, of the FIR, my lord, that is the from the cattle missing complaints, it is suspected that an inter-district theft gang is operating in an organized manner in Lakhimpur district. In this regard, Naka sacking and night patrolling were intensified at 2:05 p.m. Receive information from such and such that a such and such color of vehicle is heading towards so and so. And I, along with my staff, holds Naka at so-and-so. The said vehicle was intercepted at so-and-so and asked them to stop the vehicle, but they refused to stop and fled away full speed towards such and such. Accordingly, myself with so-and-so. And my lord, thereafter, that was, my lord, seized, my lord. My lord, that is the position, my lord.
Only allegation is that I am one of the accused.
Do you think there's a case of interim?
But it is a syndicate, my lord. Question is that it is a syndicate, my lord. My lord, steps were committed accordingly. They have different numbers of CDs and then police, my lord, make an investigation, try to find out, and automatically they find in a swift desire, my lord, they recovered. My lord.
All persons are by the time.
So, my lord, let's have a short date, my lord. My lord may be pleased to peruse the CD, my lord. Then.
And all
my
persons are already arrested.
Hmm?
All accused persons are already arrested.
Is it Tazal Islam?
Yes, he's also arrested.
Submitted that the Tazal Islam again Tazal Islam has already been arrested in connection with this case, and hence his petition has become infructuous, and accordingly Mr. Podcaster submitted that he does not want to press the petition for the PW1 petitioner number 1. Into করে দিব, এক লাইন তো লিখে দিব। Expert. It is also submitted by Mr. Podcaster that the present accused petitioner is an imam, and he is presently associated with all religious functions. However, his name has been mentioned in the FIR that he is associated with this crime, but there's no, his name is there only.
My lord, his name is there. No identification is there. Only his name is, my lord. Biological identity, that is a one person. Regarding other part, that will reveal after perusing the CD, my lord. I am not saying, my lord, in the CD, maybe his name may not be reflected during the course of investigation. That may be also found, my lord. But the thing is that, my lord, there is a, my lord, syndicate who used to the allegation of theft is there, my lord.
Considering the
And, my lord, that is also one is found, my lord, from a Swift Desire car, my lord.
I was not.
And
found.
police are trying to, my lord, nab the culprits, my lord.
All culprits
My
are
lord, that is there.
Press corridor, Baki CD call corridor. We are calling for a case diary.
My lord, but considering the, my lord, ensuing, my lord,
He is somehow protected, I think. Be arrested, and this that because he is an imam, so most probably he may not be arrested in connection with. Otherwise, also he is doing his religious work. That is one aspect when it can be 9 to 15.
9 to 15.
9 to 15. Because now I was supposing to just think the record that, but the question is that his name is there only, that he is one of the associate with the entire gang. In fact, they're doing the transportation of illegal transportation.
I cannot deny that.
Because and it is in the FIR itself is there. Let us call for the case there on 9-4. We'll see to it. But 16 is connected with 15.
15 I am here.
15 and 16 are connected. So you are for the 15?
Fine.
So now he is praying for adjournment today for 16. It will be after Bihuda. A request made by the
22nd April.
22nd of April. Can it be? 24th will any problem be? 22nd lot matters have been fixed already. First of May. Yes, it can be. It can be. 1st of May we are listing it. Both the matters.
But my lord, interim may be continued.
In both the matters, in 20 was there. In 16 it was there. 15 interim was there. No interim. In 16 interim be continued till next date. Okay. You are for it? Oh, for response number 2, na? Response number 2 pains to appear in item number 15. In item number 15, I think you are appearing. Both 16 also. 16. Both in it.
Obliged.
1-5. Okay.
For bail hearing, item 31.
Please, your lordship, can the matter may be passed over for time being, lordship? There is some next, lordship.
We have received this scan copy here, I think. Okay.
32.
My pleasure, lordship. Since the petitioner has been arrested on 25/12/2024,
25 to 24.
12 to 24.
Hmm.
Charges under BNS as well as the UPA.
My lord, in this connection, my lord, we have received the case diary, my lord. Say today is the 98th day, my lord. So, my lord, I've been informed that, my lord, they have filed IO has filed an application, my lord, to the public prosecutors for extension of time for investigation, my lord. Since it is a UAP Act, my lord. So I may be granted only 1 day time, my lord. Let the matter come up tomorrow, my lord. If the time is allowed, my lord, then my lord, may get the bail application. If time is not allowed, my lord, we will end up into go on bail. Because today is 90 days.
90 days. Maybe on 26th.
26.
Then 26th.
This one.
33.
Made legal lordship. Here, my petitioner was arrested on 28/2, my lord. 28/2, my lord. Here, my lord, whatever, he is the owner of a mobile repairing shop, my lord. Some mobiles were recovered, and among those mobile, my lord, one person, my lord, it is written in the FIR, my lord. His name is Rahul, my lord. He has given one Realme mobile to him, which is alleged to have been a stolen mobile, my lord. Page 8 is the FIR, my lord. And among those 70, only the stolen mobile has been seized by the police, my lord. Page 8 is the FIR. Though it is written, my lord, 70 number of the mobile phone, my lord, but police has seized only that stolen mobile, my lord. The seizure list I have annexed, my lord. And my lord, and that person, my lord, Rahul, my lord, he was also arrested, my lord, who has given him the mobile, my lord. It is written in the FIR. It is written in the FIR, my lord. Permit, may I read the FIR, my lord? In the last line, my lord, page 8, my lord, including Rahul, my lord, who gave Vikram Shahini the Realme phone, my lord. That is the stolen mobile, my lord, and it has been seized, my lord. Seizure list I have annexed, my lord. Page 22. Page 22, my lord. So, my lord, one mobile, my lord, he is behind the bars for almost 26 days, my lord. Page 22, my lord, seizure list, my lord. And my lord, he is a mobile repairing shop, my lord. People give mobile, my lord. He has no authority to check the, my lord, whether it is a stolen mobile or not. He gives, my lord. And that person, my Rahul, my lord, who has given him the mobile, he has also been arrested. So, and moreover, my lord, while arresting, my lord, lordship knows, my lord, I have annexed the notice, my lord, under section 47, my lord, page 20, my lord. No grounds of arrest, my lord, there, my lord. No grounds of arrest. So, my lord, considering the length of detention and the mobile has been seized, my lord, may I pray, my lord, the petitioner may be allowed to go on bail, my lord. On any condition, my lord.
The CD was called for, my lord. I have sent my lord one report, my lord. Then he was, my lord, within law and order duty for last 7 days. That is why he could not produce the case diary today, my lord. The report from my lord.
Well, one mobile, my lord, my page from Pan Bazar, it did not came, my lord. On the last occasion also, my lord, I prayed, my lord, I took the plea of section for that under section 47, no notice was served, but no grounds of arrest was assigned, my lord. Page 20, my lord. But my lord, the short date was given, that's why, my lord, by the court to assign, my lord. But my lord, today also, my lord, from Pan Bazar, and one mobile Realme, my lord, that was also seized, my lord. Police. Now, further custody, my lord, may not. He is a mobile shop owner, my lord, mobile repairing shop owner, my lord. He repairs mobile, my lord. He is behind the bars since 28/2, my lord. Further custody may not be required, my lord, possibly, my lord. He could be mobile to seize, going to pay.
That is, my lord, what I have received, my lord, that I have conveyed to this honorable court, my lord.
And the question is that suppose if he is a habitual receiver of the stolen property, suppose he may be with 70 numbers of mobile has been found in his shop, in fact. What was the purpose why he was keeping 70 numbers of mobile in his own shop? If it's a repairing shop, there may be some mobiles may be there.
But those
But
mobile
the
were not
question is that they have seized only that mobile. And without, he did not feel any necessity to going for the other.
No, my lord, as far as lordship may kindly see the forwarding report, my lord. My lord.
Procedure list,
Page number 18, my lord. Page number 18, annexure 2, my lord. Lordship may kindly consider ground of arrest matter 2 number. Number 2, during inquiry, 70 numbers of mobile handsets without any documents which is suspected to be stolen were seized and recovered from the possession of the below.
Those were seized.
All the 70 mobile phone, my lord, as per the forwarding report, it is seized, my lord.
But my lord, seizure list only one.
But
Seizure list-
Caesar list says different, otherwise. Caesar list, your page, Caesar list is that page?
main seizure list page 24, my lord. But তাতে তো আর এটাই করেছে।
Only one Caesar, one mobile was seized.
One point from him, my lord.
It is from him, my lord, probably.
But he was only there in the shop.
The other mobile also seized, my lord.
But from his shop.
No, suppose 70 mobiles, if it is seized as per the grounds of arrest, in that case, all have to be seized from his person only, because he is the shop owner. That is what I'm saying.
And my lord, that grounds of arrest plea also, my lord, for my lord, no grounds of arrest was assigned. Page 20, my lord. And the 21 is the original one. Only he has been informed, my lord, but no grounds of arrest has been assigned. So considering all, my lord, one mobile, my lord, he will definitely cooperate with the invest. Only stringent condition, my lord, may be imposed, my lord.
Heard Mr. S.M. Abdullah, the learned counsel for the petitioner. And also heard Mr. R.J. Borga, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. It is submitted by Mr. Borga that CD not received, and it is intimated by the IO that he could not send the CD as he was busy in law and order situation.
He has paid for some time, my lord.
And accordingly paid some time to produce the same. Next, Mr. Abdullah, the learned counsel for the petitioner, submitted in this regard that the present accused petitioner is closely connected in the alleged offense of theft. However, it is a fact that one person named Rahul came to his shop for repair and gave a mobile handset for repairing. And at the time of receiving the mobile handset, he did not inquire about any documents, which is not essential for him, not and required any document. But subsequently, it is found that the mobile handset was a stolen property, and then that has been seized from his possession. He is in custody since last 28/2/2025, and thus the IO was sufficient time for his custodial interrogation, and accordingly, he submitted that further custodial interrogation may not be required for the present petitioner, or for the purpose of investigation. Further, he submitted that he is ready and willing to appear before the IO and cooperate in the further investigation of this case. Next paragraph, Mr. Borga, the learned additional PP, submitted in this regard that from the boarding report itself, it is seen that he is a habitual offender of receiving stolen property, and at the time of investigation, about 70 numbers of mobile handsets were found from his possession, which were without any documents and which were accordingly seized. Mr. Borga accordingly submitted that the CD will be required to know the other facts of the case, and accordingly he raised objection in granting bail to the present accused petitioner without perusal of the case diary. Next paragraph, Mr. Abdullah submitted in this regard that there may be other mobile handset as it is a repairing shop, but from the seizure list itself, it is seen that only one mobile handset was recovered from the possession of the accused petitioner. More so, he submitted that the the notice issued to him under section 47 BNS also it does not reveal any grounds of arrest which is mandatorily required. Next paragraph. Considering the entire facts and circumstances of this case and without going into the further detail of the merit of the case, the length, only considering the length of detention, Miradi is allowed to go on bail. Where he is pending, it is pending
CGM Kamrup Metro.
with the satisfaction of the CGM common.
I'm deeply obliged, madam.
Fifty-two of the supplementary.
This matter will be taken up at 2 p.m. madam. Just now we have received the case there, madam. After the city was called for, madam.
2 p.m.
At 2 p.m. madam. 52 and 53 connected.
52 and 53, both are connected. So both will be taken up at 2 p.m.
Time being 31.
Time being?
May I please?
Yes.
I said.
This can be clear. This can be clear.
Well, initially I was on interim, this 438 bail, my lord, 3 years bail. But after long gap, when TC came, my lord, my bail was rejected. Your lordship's order is page 29, and your lordship has given a direction to appear and to pray for regular bail. That is on my lord 18/6/24. Accordingly, I appeared, but my bail was not considered, my lord. And my lord, case was charge sheeted after a long gap. That is on 12/1/24. Though I was arrested on 28/2/23, but till now no charge was framed. Total detention is 757 days.
No, earlier you were on bail.
3 years bail.
Earlier you were on 3 years bail.
Thereafter, after perusal the CD, my bail was cancelled. So your lordship directed me to appear and pray for bail. But I appeared, but no bail was considered. Can copy has come, my lord, your lordship of perusal. I am an employee of the person, my lord, where from the alleged Yaba tablet and powder-like substance were recovered.
No, interim protection was rejected not by this court, by the court below, I think.
Court below, not by you, court below. Till now, my lord, charge has not been framed, madam.
So now you are in custody since 28/2.
Yes.
Charge not yet framed.
Not yet framed.
Is what our present status report says.
Present report, my lord, there are 3 accused persons, charges that accused person, my lord. 2 were forwarded and 1 is absconding, my lord.
Still absconding.
Still absconding, and
probably
only
for
for his
that, my lord.
appearance, my lord, PNA has been issued, my lord. It is pending for his appearance, my lord. So may I pray, my lord, let the matter come after some days, my lord. Because PNA is issued, my lord, the report has not come, my lord.
Report will come, what to say.
In that case, my lord, if absconder accused is not found years after years, then my lord, I think there is a provision for segregation of the case also. That could have been done, my lord. Unnecessary detention is there.
And my lord, the status report is up to January 2025, my lord.
More or less present, you can say, otherwise, I don't know, maybe within 2 months, there may be some development.
After this status report, maybe again call for it. What is the position of this?
Yes, you want or what? Otherwise, we will pass the order.
Up to the status report, we will call for, my lord. Fixing after Bihu, my lord. So if the again.
Otherwise, it is of January.
After January 2025, my lord. The last date was fixed in the month of January 2025 for my lord, for a report and appearance, my lord.
Mr. Borga submitted the last date of the case record though received is not up to date, and the present status report is not yet received. As per the status report, the case was fixed on January 2025. But and accordingly, he submitted that the present status report of the case record may be called for. After who you want to say?
28 4 months.
Very long.
Long, yes.
Little earlier, for us.
24.
Saturday, তাহলে 28 দিনই থাকুক Let it be 28 4.
No, 24 4, you're going somewhere. 28, 22 4.
22 4.
22 4.
I have 6 days. I'm very sure.
Yes. I'm on block.
Otherwise, if you see, Borwa, this one is absconding.
Yes.
And in fact, court did not take any such steps for.
Yes, court could have taken up
the
steps, yes. Segregate
splitting
his
up of
case
the
and
case
other,
record.
he may proceed with the
Secondary
trial of the other
because
accused.
one petitioner is now saying he is behind the bar more than approximately two years.
2 years.
That- Okay, we're calling for the updated one with 22 2, 22 4. Okay. 22 4.
37.
May I please, Lordship?
37, you have received the case diary here? Yes.
Case diary received my note and service also completed my note. That is why
She is.
my cause has
active. Yes.
This 14 minute is the initial case was restarted as available section. And
Bailable section.
initially and subsequently.
Achha, initially bailable. Okay.
Initially.
Then
Subsequent-
subsequently what section was added?
74 BNS and section 8 of POCSO.
Subsequently 8 POCSO added.
Added.
Achha.
And present petition before you.
1172 is also bailable.
Total 8 number of accused, I am not of them, my lord. Total 8 number of accused, I am not of them.
No. 117.
Bailable.
Do you have any instructions regarding the ownership matter? Are they appearing physically? Do you have any instructions? To be here, Abaniki. Actually, I asked him to appear before this court physically. One Mr. Mojumdar, we have already heard. In fact, the other one is Mr. KP Pathak ought to have been here. Again, through VC then. Equal to Kwan. You are saying all sections are bailable.
Bailable.
117 is bailable.
Bailable. Even key.
What from you are saying? Therefore, 7 years is grievous hurt, in fact.
POCSO has been added, my lord.
Huh?
POCSO.
The POCSO to subsequently added, and these are also not the bailable section. Anyway, what is the case? Yes.
Case number 16, madam. When the
16.
orders it reflected.
Page number 16.
16.
Ah.
Then 17. 329, subsection 2, 117. 2,
3.5 BNS rules are available section and hence the petition number so and so is allowed.
So you are on bail.
Initially on bail, subsequently at section, some of the aggressive action are added there.
So after adding of section, whether there is any search for you?
No,
Then-
yes, madam. Basically, my lord, allegation is of assaulting my lord.
Assault.
Assault. While one boy and girl talking, sitting in the premises of the informant, some of the people have entered the house and beating them. This is the allegation made. In this section, some of the petition.
Where is the FIR?
Is 14 my lord, particular portion. May I read out my lord? সম্মানপূর্বক বিনীত নিবেদন এই যে যোৱা ইংৰাজী so তাৰিখে সন্ধিয়া প্ৰায় 7মান বজাত মই ঘৰত নথকা অৱস্থাত মোৰ ছোৱালী so ঘৰত আছিল আৰু একে গাঁৱৰে ল'ৰা সদাগৰ আলীয়ে মোৰ ছোৱালীৰ লগত কথা পাতি আছিল তেনে সময়ত উক্ত পদকীয়াজনে মোৰ চোতালত আহি বাঁহৰ লাঠি আৰু দাও ইত্যাদি চোকা অস্ত্ৰ লৈ ল'ৰা ছোৱালী দুটাক হাতত বান্ধি লৈ নানা ধৰণৰ অত্যাচাৰ লগতে বৰ বেয়াকৈ মাৰধৰ কৰি শৰীৰৰ বিভিন্ন অংশ জখম কৰে।
Yes.
Section 74 and minor 8 of POCSO was added, minor. Letter.
Is there any ingredients of section 8 of POCSO?
Yes, my lord. Because my lord, the victim, my lord, she is aged about 17 years, my lord. Now she was, my lord, sitting, my lord, with her friend, my lord, co-villagers, my lord, Sodagar Ali, my lord. Then some villagers, my lord, they caught the both victim and our friend, my lord, and they were assaulted, my lord. And my lord, as part of my lord, statement of the victim, my lord, this accused person, my lord, he is specifically implicated, my lord. He touches her chest, my lord.
He is not in the place of occurrence.
That is the allegation against him, my lord. Otherwise, my lord, all the accused persons, my lord, there are several accused persons, they all assaulted them, my lord. As far as the injury report is concerned, my lord, that is, my lord, simple injury, my lord. But that allegation is there, my lord.
At the time of adding these sections, those were brought.
My lord.
Section was added na, at the time of
Section
adding
was-
this section, after recording her statement.
After recording
section.
her statement.
Her 164 is there.
Yeah. But down below it, the last one.
Yes, that is irrelevant.
You only matter this specific allegation, my lord.
He is Sahadul, na? Sahidul.
Sorry.
Yes.
So Lordship, I concur with the learned PP, because earlier when this FIR was lodged, it was lodged by the mother of the victim. So that time it may be very obvious that she may not have all the names, but the victim, since she was already at the place of occurrence. So only after her statement was recorded, then these sections, the specific allegation was brought only against the petitioner. So the learned counsel's submission that these are bailable offences, and only because the rest have got bail. So that is why the petitioner is also entitled to bail. No, your lordship, it does not stand in this case because there's a specific allegation.
No, he says that earlier he also got bail.
Yes, your lordship, but I did not find that order anywhere.
Where is the order? Your bail granting to you also? Is there?
I'm not prefer my lord in bail matter. I'm not prefer my lord.
Or you have not preferred any bail application?
Subsequently, police searches me, search me.
No. The other persons, they have appeared, they were granted bail.
Granted, my lord.
And you have not appeared.
No, my lord. Even my name is not shown in the FIR.
Not shown in the FIR.
FIR, my lord.
Acha. Others got bail.
Got bail.
No, you just that time you told me that all are bailable. Then again you said that you earlier initially got bail. That's why I thought that you also got bail.
Even my lord, some of the accused of the preferred this bail petition and subsequently court allowed them. My lord. Yeah, even my lord, High Court also approached my lord, some of the
Other persons.
Yes, my lord.
Obviously, there is no report, I think. Is any other submission regarding this anticipatory?
Yes, your lordship, because as he's submitting that the others had approached his honorable court and they were given bail. But the thing is that there are no specific allegations like under these sections against the other petitioners. But the only specific allegation which attracts the section 8 of POCSO is only against this petitioner, your lordship. So your lordship may kindly consider that aspect. That's all. Your Lordship.
Yes. Okay, any other submission? She brought specific allegation against you, in fact.
Go by
In
164.
164, yes. Specific allegations.
Up to your lordship.
For that allegation only, otherwise it was a case of assault and all. But subsequently against you, the allegation she brought, for that reason only the IO had to apply or had to pay for addition of section 8, in fact. Otherwise, it's not a case of section 8. Otherwise, if you go by the FIR. You are Mr. J.A. Ahmed.
Ahmed, my lord.
Heard Mr. J.A. Ahmed, the learned counsel for the petition. And also heard Mr. R.J. Burma, the learned additional PP, appearing on behalf of state respondent. And MS M.K. Brown, the learned amicus, appeared on for the respondent number 2. This is an application on section so and so in connection with so and so. City receipt, where is the same Hartford City. Next point is submitted by Mr. Ahmed, the learned counsel for the petitioner, that all the sections alleged against the FIR, sorry, initially the FIR was registered under all the bailable sections, and all the co-accused persons were also enlarged on bail, considering it to be a bailable offense. But full stop. But subsequently, on the prayer made by the IO, section 8, 74 is also added.
Yes, sir.
74-2.
74.
74-4. Reason of the IO, the section 74, section
74. Your lordship, only 74.
70. This is your second time petition.
No, my lord.
But some of the petitioners were enlarged on bail.
This court as well as the POCSO court, my lord.
So you have an XD order also, na?
Yes, my
So
lord.
why don't you submit all this?
Page 13.
Yes, but those were allowed considering the fact that there was no specific allegation against those petitioners, in fact, the earlier petitioners, only against you, this petitioner. It is 74, sorry, 74, read with section 8 of the POCSO has been added. As it full stop. Next part, if it is submitted that accused committed no offense as alleged in the FIR, and from the plain reading of the FIR itself, it is seen that it is a case of assault, wherein the boy and victim girl was alleged to be assaulted by some villagers. However, Fostavi is ready and willing to cooperate the IO in further investigation of this case if he is granted the privilege of bail, anticipatory bail. Next one, Mr. Borga, the learned additional PP submitted in this record that it is a fact that earlier the case was not earlier the case was registered only under section 329(2)1172 oblique 3 subsection 5 of the BNS, but subsequently on the prayer made by the IO, section 74 BNS, read with section 8 of the POCSO, has been added. So he further submitted that the victim clearly brought the allegation against the present petitioner only regarding his sexual assault on her, for which this section 8 of the POCSO had to be added by the had to be added full stop. Accordingly, he raised objection and submitted that it is not a case for anticipatory bail. Next para, S. Brown, the learned amicus curiae, also submitted in this regard that initially the FIR was lodged by the mother of the victim, and it is a fact that while lodging the FIR, only the allegation of assault was brought. But when the statement of the victim was recorded, they found sufficient materials to add section 74 BNS, read with section 8 of the POCSO Act. Accordingly, she raised objection and submitted that his bail prayer should not be granted at this stage. Next one. Hearing this submission made by learned counsel for both sides, I have also perused the case record, especially the statement made by the victim under section 183 BNS. It is from this statement, it is seen that the victim specifically brought the allegation of sexual assault on her, particularly by the present accused petitioners. However, against the other accused persons, there is no such allegation of a sexual assault except the present accused petitioner. Considering the entire submission made by learned counsel for both sides, materials available in the case diary and other aspects of the case, I do not find it a good case to extend the privilege of clearance to the present accused petitioner, and hence this substance rejected. Girl was 17 years.
70, so far my knowledge was 17.
17.
Per 183, 17.
Huh?
As per our 183 statement.
Okay, let's see that. Okay.
May please your lordship. Lordship, this is an anticipatory bail application on the, as per the last order dated 3/3/2025.
You are on interim.
I am on interim and case diary was called for. I was granted the interim on the strength of a hire purchase agreement. Basically, lordship will first peruse the FIR. The FIR is at page 21, the effective portion of the FIR.
31.
Page 21.
21. Yes.
May I read the FIR, lordship? With reference to the subject cited above, I have the honor to state that as per the FIR lodged by, there was one prior FIR also lodged. Basically, I am the owner of the vehicle. The vehicle that is involved in this case, I am the registered owner of the vehicle. But 1 year prior to the lodging of this FIR, I had entered into an hire purchase agreement and I had disposed of the said vehicle. So, lordship, section 2 clause 30 of the Motor Vehicles Act is applicable to the petitioner in this case. Given that the vehicle is under hypothecation and somebody else is under the control and dominion of the said vehicle.
So what had happened was a third person had applied for Zimma of the cement bags that was being transported in the said vehicle. While granting Zimma, it was granted while releasing the said cement bags, certain IMFL liquor bottles were found. So accordingly, this FIR was registered. So otherwise, I have nothing to do with the cement or the liquor or even the vehicle. My nexus is limited to the fact that I am receiving monthly EMIs. So if your lordship will see page 43. Page 43 happens to be the hire purchase agreement that I had entered into 1 year, almost 1 year prior to the lodging of the FIR.
So we have received the case there, my lord, but by order is 3/3/2025, my lord. This honorable court has granted interim, my lord, to cooperate with investigation authority, my lord. But from the case there, it is not clear, my lord, whether he has appeared before the IO or not.
Lordship, that as per my, he has appeared.
But that is not mentioned in the, my lord.
His statement is also not there.
No, not there, my lord. So, my lord, I may be allowed to, my lord, further up to the case there.
Yes, why your statement is not there? Is this case
Lord,
diary is
this is-
till last
Last
entry of the case diary is seen.
In fact, he's a resident of UP. He had
27/1, my lord.
Huh?
27/1.
27/1.
My lord. But my lord, why forwarding the case diary, my lord, it is dated for 21/3, my lord. There is one forwarding letter, my lord.
Forwarding letter of this
The case diary, my lord. That is on 21/3, my lord. But we have to end, my lord, inquire, my lord, whether, my
If
lord,
it is 21/3,
21/3, my lord. That is,
then obviously
forwarding letter is up to that, my lord, but if entries in the case diary, my lord, that is not up to that. My lord. That we have to ascertain, my lord, whether he has appeared or not.
you, Mr. Kothari. Heard Mr. D.K. Kothari, the learned counsel for the petition. And also heard Mr. R.J. Borwa, the learned additional PP, appearing on behalf of state respondent. As case CD received, but it is submitted by Mr. Borwa that the last entry in the case diary is of 21/5.
21/1, my lord.
21/1/2025, though of the 25, and his statement of the present petitioner is also not available.
Well, I'm sorry, my lord, 27/1, my lord.
27/1 করে দিব। Not available in the case diary. Accordingly, he submitted that from the full stop next one. Accordingly, he submitted that. No. Accordingly, he submitted that the updated case diary will be required, and as it is not, as there is no material to. As the statement of the victim, as the statement of the petitioner is not available in the case diary, he is not in a position to say as to whether he appeared before the IO after obtaining the interim order of interim pre-arrest bail on 3/3/2025. Next para, Mr. Kothari, however, submitted in this regard that as per instructions from his client, he had already appeared and his statement is recorded. Next, in view of this, let an updated case diary be called for, and the IO is hereby asked to attach the statement of the accused petitioner if his statement is already been recorded, and let the matter be listed when it can be listed. 25/4/2024, until then the interim will be extended, your petition. And if you not appear, suppose any reason, you can appear if it is not appear. 25.
Deeply obliged.
এখন মাত্র দেখুন কি আছে বেল আছে নাকি বেল are over. 1 fixed at 2 p.m. otherwise the admissions. Already fixed at 2. Two matters are already fixed at 2. Most probably TD received.
Yes, what you say, case diary is item 52 and 53, my lord. That is at 2 5.
Both 15 and 16 covers it, or some 51,
Not
50 to
50,
50 to 53.
50 to 53.
52. It's 50, 52 and 53. These are fixed at 2. And then we can
50
start.
is a motion matter.
50 is a motion matter. It will answer 9 here. Admission fee as a solution. Because at 2 visit was and one. So
12 for admission.
no, that means 1. These are the 1, 2, 3, 23. Four, no? After there, 5, 6, 10, 7.
My lord, item number 40, my lord.
40.
So I'm not feeling well, my lord, because replacing my friend also. Can it be taken up day after tomorrow, my lord?
You both are not feeling.
No, I'm not feeling well. I'm taking this consent, my lord.
As now was praying for adjournment with the consent of the other set. Hard Mr. Agora and also hard Mr. S. Navas. Adjournment pre-consent where to which the Bora Mr. is no objection. When it can be fixed?
Day after tomorrow.
Leave petition, my lord.
It will only take 1 minute of your lordship.
Leave petition.
Yes, lordship.
Day after tomorrow is a
As per your lordship's convenience, my lord.
27. 27.
26.
26 can be fixed. And we have fixed some fixed matter, that's why I just what matter fix was saying 26 or 27.
For your lordship. Any date on 26 or 27 as per your lordship's convenience.
27 for you. 27. 27.
My lord, item 24, my lord, after 2 weeks, my lord. Admission matter. 24.
After 2 weeks, 2 weeks. Just after 2 weeks. Same ground table is not feeling well. But you have fever now.
Or she had deep illness.
At 2, we have one matter from Arunachal, in fact, thereafter I'll just.
For order, selection petition 5 of 24.
Mr. Pana, you are not audible, in fact. You are not audible.
Please unmute yourself, sir.
Mr. Tagu, unmute yourself. We are not hearing. You are not audible. Hearing no like
Lordship.
yes, I can hear you, but there, Mr.
Yes,
Tagu
Lordship.
is not audible. Yes,
Lordship, they might have not unmute the mic here.
they have not unmuted.
My lord. Women.
Am I audible, my lord?
Yes, yes, now you're audible, yes.
So my lord, the leading counsel could not come today, my lord. So item 1 may be kindly fixed on 3rd of April, my lord.
Third, I have got some difficulty. Let it be on 10th then.
Then
10th
can
is
it be
third.
on 4th, sir? 4th instead of 10?
No, third and fourth I have got some difficulty. Let it be 10th. 10th is a Thursday, man. Hearing.
Convenient for you, Mr.
My
Thakur?
lord.
My lord,
On 10th.
10 man.
So we are adjourning the matter till 10th.
My lord.
Yes.
And second item.
And
Have you filed any adjournment, I mean, IA for adjournment today?
today,
Normally it is required to be filed.
It is to be filed by election petitioner, my lord.
we have not filed, my lord. Yeah.
Otherwise, it's required, in fact.
Yeah.
Anyway, considering your submission, I am just granting it. Yes, Mr. Mojumdar, on 10th we are fixing.
Yes, ma'am.
You are appearing for the respondent, Anju?
Yes, Your Lordship. In IA, I'm representing opposite party number 2.
Opposite party number 2, okay.
Returning officer.
10. Obliged.
Deeply obliged.
Item number. Yes, my lord, in item number 2 also, we are representing for the petitioner.
So represented by whom, Mr. Thakur?
Yes, my lord. Affidavit in opposition also we have filed to them.
No, we have just received.
We have just received the affidavit filed by the other party, my.
No, item number 2, you're for the petitioner?
Yes, ma'am.
And I order 7 rule 11 application and reply.
The connection with election petition 4.
Yes.
So in election petition, you are for the petitioner or for the respondent?
I'm appearing for respondent, return candidate.
Return respondent.
Yes.
In item number 2.
Yes.
And you are Mr.
K. Dabi.
No, yes, you are K. Dabi. No, yes, Mr. Pada, you are appearing for
Petitioner.
Election petitioner.
Yes, ma'am.
IA is filed by whom? One IA is there, 56 of 2025.
56. This 56 is filed by return candidate. For that, they are supposed to file reply today, but not file.
Have you filed it reply?
Yes, no, my lord. Since he is having some health issues, my lord, today it could not be filed.
In another miss case, I filed my reply.
Where? In election petition?
No, IA 58.
58. IA 58, he has already filed his original objection. And IA 56. And in IA 56,
We'll file the
we'll file a reply, ma'am.
Verify and time accessibility by IA 56, Mr. Opada. And Pada, sorry. And
April,
Mr. Pada, you are saying about senior counsel who is Mr. Apang or who?
Mr. KP Patak, sir, ma'am.
What is the KP Patak?
Yes, ma'am.
Then 14, मेरा कैलेंडर कौन
से 11 तारीख से छुट्टी है 11 तारीख से छुट्टी है 12 13 14
Here also can we fix on 10th?
No, 8 में कर देता है 7 में
On 7.
On 7, man.
On 7th?
Yes.
Okay, we're fixing it on 7th.
Yes.
Up on 7,
upon 7, Lamnate.
See, in item number 1, we have already heard the submission of from most probably from D.
Yes.
Mazumdar.
Yes.
Yeah.
So if Mr. Pathak is available here in physically in principal seat,
That
then
will try
it
to
will be convenient
continue.
for us also. Then we can call for the record. I mean, record will be with us, no issue.
Yes.
If we,
Item 1 being
if we can appear physically from the principal seat,
Yes,
then
Lordship, I'll
convenient for
convey.
us.
Yes, Lordship, I'll convey it to him.
Both the councils have, we can hear from the principals and it will be convenient for us also.
Yes.
Instead of through VC.
Yes, my lord.
Can be possible. Okay.
Obliged, ma'am.
First, kindly give me some time, your lordship. After 2-3 items, your lordship, kindly.
2-3 items. Your affidavit, I mean,
Yes, lordship has come.
additional affidavit has already we have received.
Yes, lordship, but one document we have collected, your lordship. Kindly give me 2 times.
Okay.
52 and 53.
Days, lordship, and yesterday we had a 60 days, lordship.
55 days in custody.
Lordship.
Yes.
Yes. My lord, here, my lord.
What nature of case this is?
It's a cyber crime, my lord. Some and laundering of money. Actually, my lord, some mule accounts that were procured, my lord, the gang is there, and then thereafter some kinds of transaction thereof. Unknown sources. Suppose somebody is transacting an amount of crores, he will get 20 lakhs because of you. He has given for the use of that particular account. Like in similar way, even one accused doesn't know another accused who is involved. It is from the as per the allegation and from the FIR, that is, it is operated from Chhattisgarh. And some people, those who are very much connected with the syndicate cyber gang, that is my lord, connected here also. They collected some accounts, transactions were made, my lord. On the basis of some information, my lord, the item number 52, my lord, that is the present accused petitioner, who was apprehended, my lord, on the same day. And then thereafter, the investigation progress. Now it's going on, my lord. And in the, my lord, 53, my lord, another accused person who was arrested on, my lord, that is 16 to 2025, my lord, thereafter. My lord, regarding that, my lord, that is item number 53, my lord, that is one Bonojit Bora, my lord, police has also filed one, my lord, objection, my lord, with a prayer not to grant bail because, my lord, this is a cyber crime and they very much, my lord, there is sons of, my lord, tampering the evidences, my lord. Even sons of manipulation. The witnesses.
Give participant number,
Mr. Bhushan, I'll just tell us one thing as he submitted by Mr. Munir.
Right.
That he is in the item number 52, he is in custody since last 55 days.
Yes,
Is there any
my lord.
probability of, do you have any such kind of information regarding the probability of filing the charge sheet within 4-5 days or within
My
6-7
lord, that
days?
is not there because, my lord, here only they have filed one, my lord, that is a with a prayer of objection regarding, my lord, this is
Item 53.
Item 53. And what I understand from that, my lord, more time police needs, my lord.
Admittedly, it's a case of 60 days offense.
No, 60 days.
You just see.
60 days, lordship.
Allegation of criminal conspiracy, 61, 318 sitting, 319 sitting by personality, 336 forgery, and 316 criminal breach of trust.
The highest is 7 years, lord.
7.
Forgery lordship, 3363 is 7 years. Honorable lordship, we have got that 2 persons have already granted bail from the CGM lordship.
Lordship, June Rahman and Jyoti Das, who are linked with this case, were the accused, were granted bail on 7th of March.
Rahman from his lead, my lord, that is the item 53 accused who was arrested from that lead. He is not FIN person. 53.
I'm not
He is in a, my lord, has a consultancy, my lord, engineering, medical. But that, my lord, current account was used for this purpose. And other than also other things are there.
I'm the one to be got arrested first lordship. From my arrest, the FIR has been lost. Transaction bank local information The other part is that lordship he is from here itself lordship come at any point of time lordship he can there are only 5 days remain lordship here. He is from Nunmati lordship. At any point of time he can appear lordship. Any condition may be imposed lordship already 55 days. And they as per the FIR reveals lordship they are not the main kingpin lordship. They only get some money when they get transacted in their own account lordship as per my understanding from this FIR lordship.
They are collecting people also.
Accounts are not fake accounts. Accounts are not fake, it's not fake. The accounts are original lordship, but the person lordship, they get transacted money from the other sources lordship, that is the case. And in return, they get few amounts. As per my understanding from the FIR. Because this thing which has been seized from this present petitioner lordship, that things were original lordship. Some bank opening forms were found in his name. Some passbook has found, that is also his name.
So he used to open account in the name of others or what?
No, his own account. His own account.
I mean, transactions were made through his account.
Oh, so some transactions were made. That was the allegation lordship. Of the entire case lordship, allegation that several percent accounts were genuine. The 7% lordship that they collect several percent and amounts were deposited in their account lordship. As per the allegation lordship. And in return of that, receiving of that amount, they get a bigger amount.
That amount was shifted to another person.
Another person or withdrawal lordship that further is not be disclosed in the FIR. It says that in return they get some money lordship. For that money, they accept the amount in their account lordship. Otherwise, it's not a case of that fake accounts are open in a fake name and that is not the case lordship. And this person is also not the king person, kingpin person. As per the FIR itself, it has been operated from Chhattisgarh. Some other person has been named in the FIR. Sorry, Jharkhand lordship.
From where you are saying that the objection must file for the 53?
53, my lord.
53 objection is filed.
No, my lord, they make a prayer, my lord, police. In the, my lord, I have flagged.
Both for 52 and 53?
No, my lord, for 53 one. Bonojit Bora, my lord. My lord, in the first part, I have flagged my prayer. Other, I didn't get, my lord. And he was arrested in later part, my lord. Taking the lead of that.
Yes, okay. Yes, Mehdi.
Lordship, Lordship has already gone through the list of the case. It is operation of Mule account, Lordship. And after a series of arrests that has been made, upon a co-accused statement, I have been arrested in the Lordship. And other than co-accused statement, Lordship, whether there is anything against me, Lordship, other than co-accused statement, because mere confessional statement would not amount, Lordship. And today it is 39 days, Lordship. And my custodial detention at this stage might not be required, Lordship, because as of now, for interrogation, I have not been approached, Lordship. And
you are 2 days police remand, I think.
I have been thoroughly interrogated in the police remand. I have been 2 days in police custody, Lordship. And other than that, Lordship, also the mandate of 47 and 48 BNSS is also not complied, Lordship. Lordship it might be there in the CD, Lordship. And the ground of arrest has not been communicated properly, Lordship. Other than confessional statement of the co-accused person, there is nothing against. Whether there is anything against me, Lordship. That might be taken. I am a reputed businessman, Lordship. If my appearance is required, Lordship may impose stringent condition, Lordship.
Mr. 52 Aniba Agote. Mr. S. Muni, the learned counsel for the petitioner, and also heard Mr. P. Busher, the learned additional PP on behalf of state respondent. This is an application under sexual issue in connection with swears. CD receipt, whereas the same hard both side. Next one is submitted by Mr. Muni that the present accused petitioner is innocent and is not connected in the alleged offense as stated in the FIR. However, it is a fact that some documents of the bank accounts, ATM card, etc. were recovered from the possession of the present accused petitioner, but they all are found to be genuine, and it's not a case that he operated any account by creating any creating any false account in the name of another person. Further, he submitted that the entire transactions were in fact done from Jharkhand and Jharkhand, full stop. More so, the accused petitioner is behind the bars since last 55 days, and thus the IO got sufficient time for his custodial interrogation. Accordingly, he submitted that further he submitted that the accused petitioner is from Kamrup district and he will appear before the IO at as and when his interrogation or his presence will be required. Post. Next para, Mr. Busha, the learned additional PP submitted in this regard that during the investigation sufficient incriminating materials has been collected by the IO and it is a cyber crime and the one entire gang was operating was involved one entire gang was involved in the state offense and they used to victimize some poor financially poor person and transactions were done through their account for the transactions were done in fact through their account and they get the
accounts because Mule accounts, my lord. Now, my lord, thing is that, my lord, money is, my lord, transferred through these accounts, my lord. But this is, source is, my lord, that is not known how it will come, my lord. And my lord, allegation is that these are the stolen money as because of that are, my lord, transferred in various ways, in various numbers of accounts, my lord. And the person who is giving those accounts for use is getting a particular amount, kind of money laundering, my lord. Though, my lord, this is not the police is not the special agency for go for PMLA, my lord. But my lord, that part is clearly they have stated that such kind of laundering is going on regarding this state.
But the money, the commission, who gets the commission?
Commission, my lord, those who are giving, my lord, here
Accounts.
these accused persons, and they are not only giving their accounts, but they are influencing taking others' accounts.
Yes,
So
yes.
this way, my lord, this is the nexus.
Submitted that some through their accounts and they also victimize some other financially poor persons to give their accounts for the said transactions. But till that, the investigation is going on as to know the source of those transactions, and it is seen that and transactions, and it is suspected that all the money were from maybe stolen or it's a stolen, you cannot say stolen money, you cannot say from
Basically, unaccounted, unaccounted money, my lord. These are unaccounted.
Basically unaccounted money and source is yet to be investigated by the police. However, next para, and the investigation is still under process, and though the case is not registered under PMLA Act, but it seems that it was one kind of laundering was going on, and the money transactions were through their account. Accordingly, Mr. Bosher submitted the raised objection in granting bail to the present accused petitioner. Next, for hearing this submission made by learned counsel for both sides, I have also perused the case diary, wherefrom it is seen that the IO has already collected sufficient incriminating materials and from against the present accused petitioner. However, it is admitted fact that the case is still under investigation and as stated by Mr. Bosher, the source of money, etc., are yet to be investigated by police. However, it cannot be denied that the accused petitioner is behind the bar since last 55 days, and from the submission the submission made by the learned additional PP, as well as from the materials from the case diary, it is seen that it can be held that the chances of furnishing the charge sheet within 4 or 5 days, it may not be possible on the part of the investigating agency. In view of this, only considering the length of detention, without going into further detail of the merit of the case, and only considering the length of detention, I find it proper to allow the present accused petitioner to go on bail for rupees. Where is this pending?
CGM
Kamrups, to the satisfaction of the CGM Kamrup Metro, so and so. Next to Tahibo 53.
My lord, in item number 52, it is today is 57 days.
57 days.
57
days. Going
Because
not
arrested on
55 days.
27/1/2020.
So probability of filing charge sheet within 4 or 5 days is very less. Will Now coming to the case of 53, it is next para. Mr. Medhi, the learned counsel appearing for the petitioner, submitted in this regard that present accused petitioner is no way involved in the alleged offense, and he is purely a businessman full stop. On the basis of the statement of the co-accused only, he got arrested in connection with this case. However, after police remand, after remanding him from police custody, he was not further interrogated by the IO. Mr. Medhi further submitted that accused petitioner is in custody since 16/2/2025, and thus the IO got sufficient time for his custodial interrogation, and hence further custodial interrogation may not be required for the purpose of investigation. However, he is ready and willing to cooperate the IO in further investigation of this case if he is granted with the privilege of bail. Aru Mr. Bushor same submission diva. Mr. Bushor Patu subsequent letter submission diva. Further, Mr. Bushor submitted that the IO had filed their written objection not to grant the present accused petitioner as his custodial interrogation will be required for further investigation of this case, and in the same time, it is stated in the objection that there is every chance of tampering with the investigation if the accused petitioner is released on bail at this stage. Further, Mr. Bush submitted that considering the bail objection filed by the IO vis-a-vis the gravity of the offense, and also considering the fact that the process and the investigation is still under process, the accused petitioner may not be granted with the bail. Next, Procurator report. Hearing this submission made by learned counsel for the so and so, it is seen that the IO had collected sufficient incriminating materials against the present accused petitioner, and it is not a case that on the basis of the statement of the co-accused only, the present accused petitioner got arrested in connection with this case. His further custodial interrogation may be required in the purpose of investigation, and accordingly, I do not find it proper to allow the accused petitioner to go on bail at this stage, and hence the same stance is accepted. I have granted bail only considering the length of detention, 57 days. Same, it is not the
7 days.
yes, 37 days.
37
So
days.
let's
Second
the progress further.
My lord.
Case is a serious nature of
My
offense, in fact. Okay.
Much obliged.
52 grant policy, 52 to grant one, 53. Last time it was really understood. Last exercise. This question before anything, the case of the present petitioner was actually rejected on 17/3, most probably, if I'm not wrong. And subsequently, she appeared with a new development that he was forwarded, in fact, in a gambling and betting case. And subsequently, he's shown as an accused in that NDPS matter. So indirectly, she brought some allegation against the police officer. So we were asked, and that asked was there most probably, to file an additional affidavit, bringing if there is any allegation. So now additional affidavit she has filed already. Do you have any copy with it?
Have the copy of the additional.
You have not
Only I-
furnished to the copy.
Maybe my lord, but my lord, maybe my lord, it is, but it is only I have only the copy of the petition right now, my lord.
Okay, otherwise also it is case, it is the motion stage only.
Yes.
You can peruse our copy. I have also not gone through if anything is there.
Page number 30. Page number 4. Page number 30 is the last line. And the FIR was 11 to 25. No analysis is the leaders, the main leaders under the gaming and betting act.
মানুহজনৰ নামটো আছে নেকি?
Oh, last line. Last line, last para. Last of the second para. After completion of all formalities. No. First para, last line. Omit has been Nozrul Ali of the Samata Pothar and Dildar Ali of the full singer Omit Hazarika, Nozrul Ali and Dildar Ali Sekada, main dealer bookie of the illegal tier gaming and running their illegal business at Sonapur place area under their leadership.
But arrest কৰিছে নেকি নাই কৰা?
After then, he is called for the gaming and betting at the police station. And our message is page number 33. Page number 33. Page number 33, yes. February 27. February 27 message. An EZPD team from Sonapur PS apprehended Nozrul Ali of Samata Pothar in connection with a case under the Assam Games and Betting Act.
সাতাইশ ফেব্ৰুৱাৰীত মাতিছিল।
27 February.
কিন্তু তেওঁক এৰেষ্ট কৰা নাই।
মোক ক'ব দিয়ক।
Submission to be.
Lordship, page number 31 of the affidavit, Your Lordship. The FIR was lodged by the Deputy Nath of the police officer on dated 11/2/25 of the first para of the last line, Your Lordship. The alleged person has been apprehended for interrogation, and during interrogation, he disclosed that he has been running business of tea illegally since long with the main bookies of Omit Hazarika of Boruabari, Nozrul Ali of Samata Pothar, and Dildar Ali Sheikh of the Tulsi Nagar. Lordship, in this case, his name is, he is the FIR name accused person. And he was calling on the police station, Your Lordship, on page number 33 of February 27. And he was shown arrested in this case, Your Lordship.
Is he shown arrested?
Shown arrested in this gaming case.
Say he's shown arrested.
My lord, I didn't get that whether he was what I understand is that there is an FIR where, my lord, the banning of act is there.
Yes.
One person was apprehended, and during the course of the investigation in the FIR, what is stated, the present accused petitioner is also one of the accused who is involved with the case. Now the rest part, my learned friend will say whether in that case he was arrested or not. Thereafter, my lord, in another date, that is what my learned friend has stated, he was called by the Sonapur police for interrogation. What I understand from the affidavit, my lord.
Yes.
Am I right?
Yes.
Okay.
He is called for the interrogation at the Sonapur police station, Your Lordship, for the only gaming and betting act. On kindly go to main petition of the forwarding report, Your Lordship.
This
Page
page.
number 70, your lordship. Here have date of forwarding 27/2/2025, and he was forwarded to NDPS case, your lordship. But he is the FIR name accused person in this gaming and betting act. He was not arrested on the day, and he was forwarding to the NDPS case, in this case, your lordship, on dated 27/2/25. And he was calling on the date 27/2/25 for interrogation only for the gaming and betting act, your lordship. And the message of the commissioner also, I have submit the additional affidavit, your lordship, on the page number 33. Police Commissioner of Guwahati, February 27. Message is February 27 of the first line. An EGPD team from Sonapur PS has apprehended Nazrul Ali, 38 of Samota, in connection with a case under the Assam Games and Betting Act. But he was forwarded to jail in a NDPS case, your lordship. And our FIR is, your lordship, on the main petition on page number 11. In this case, your lordship, my name and is not mentioned in this FIR, your lordship, but the co-accused also not given any statement before this FIR also, your lordship, which does not mention by the police officer informant also. In this FIR, no any statement has been mentioned that I am involved in this case, your lordship. Like this, your lordship, in this.
Gone through the page number 33.
My lord, there is a, my lord, that is what I understand, that is either a Facebook message or, my lord, that may be a, my lord, this one. Twitter na Facebook.
Lordship, the FIR is different here, your lordship. Kindly go
Case
to
number, etc. not here, in fact.
My lord, সেইটো আপুনি যে 33 যেটো দিছে আসাম পুলিচৰ কিবা এটা, whether that one is a Facebook message.
Facebook message হলো it is phone arrest কৰিছে নহয় আৰু ইয়াতে FIR খন আছে।
Phone arrest
Yes, yes.
এইটো কি হয় আপুনি
এইটো পুলিচ অফিচাৰৰ
নহয় এটা পোস্ট about photos মই এইটো কি হয় এইটো WhatsApp নেকি এইটো কিহৰ মেছেজ
Give me the petition, submit me.
but police commissioner at Guwahati, what I understand, my lord, I'm not sure because my learned friend will enlighten us, but what I understand from that, my lord, page, it might be a, my lord, account of Facebook or it might be Twitter
Lordship,
account.
okay, lordship, but his FIR is, I have annexed in here under additional affidavit on page number 31. There have mentioned that he is involved in the gaming and betting act, and according to the co-accused statement.
Now Busho is asking him whether he has been forwarded or arrested in connection with that gaming and betting also.
Yes, lordship.
Where is the forwarding report?
Forwarding.
Oh, it is the shown arrest report. We are kindly sorry for submit the loose address. I have
Shown arrest in which case?
13/3. He was shown arrested.
No, in the banning act. Banning act or
Gaming
case?
act.
In the gaming and betting act, my lord.
He was arrested,
Shown arrest.
in 33. But he was called for this case on the 27/2/25. February month of 27.
At 13/3, he was shown arrest in gaming betting.
Yes, lord. But I am the
My lord,
FIR name
he is
accused person.
arrested in this case, my lord. Definitely shown arrest, my lord.
Lordship,
thereafter.
my question is, dear your lordship, there have a difference between the FIR, your lordship. In this FIR page number 31, here mentioned by the co-accused that Nazrul Ali Sheikh and the Dildar Ali Sheikh and Omid Hazarika is the involved in this case, according to the statement of the accused person, who was the arrested person. But in this NDPS case, does not mentioned by the accused person. Same thing, your lordship. Only on yearly Sam recovered from him, so and so, and no any statement is mentioned in here. That yearly never statement in here that he is involved in this case, your lordship. But in this FIR, in the gaming act, kindly go to FIR page number 30.
Yes, I have seen.
Ohidul Ali has mentioned, stated that they are the involved in this case, your lordship. Directly, they are the FIR name accused person. But on the day 27/2, why they have not arrested to the accused person in this case? Because he is the FIR name accused person, your lordship. And he is not a FIR name accused person in this case, and FIR was lodged of the main petition on 7/2/2025. But here never statement is, I have find anything about that he is involved in this case. Like this FIR, he is involved in this case. They are mentioned by the co-accused, but there have no any co-accused mentioned in here. Lordship, so he is involved in this case is sufficient, your lordship. I know. And your lordship?
My lord, my one,
And-
my lord, there before
Yes.
your lordship is there, my lord. Because my lord, there are, what I understand from my learned friend's submission, there are two numbers of cases, my lord. There is a pending before one petition, and both the matters are different, my lord. So my lord, right now, I don't have that copy. If my learned friend allow me that copy and give a 1 day time, my lord, tomorrow after going for the.
We are not forgetting the cases. My main question is that one petition was moved for the present petitioner in connection with that present case and
Present case, NDPS case.
that has been rejected by this court
My
after
lord.
perusal of the case diary.
My lord.
Maybe I think after perusal of the case diary, whatever. So you say he has already yes, 73 it was rejected. Now subsequently after 70 rejection order, he came a fresh petition with a fresh petition for bail. That can be, it's okay. It can be. So now this, while filing the present petition, the counsel came with a plea that actually he was forwarded in a connection with one gaming and betting case and not in the case of NDPS. And accordingly, we asked her to submit things because it is a serious allegation against one police officer. If it is the position is in that regard, then it's a very serious. So we asked her if anything is there. She came with this this post only. Post, I don't know, I'm not sure about whether it's a Facebook post or what post. So that is not sufficient. So you come with a petition. So now she has come with a petition. I have not seen anything here, except she enclosed the FIR of that connected other cases. Obviously, admittedly, the name of the present petitioner was uttered by one of the apprehended accused. But the question is that when most probably it is in case diary, that while investigating the case or this time of after apprehension of the first, after apprehending the other one, it has come to the knowledge that he is the person who is the kingpin of the entire case. In fact, he used to supply ganja and things are all these things. So that's how he was arrested and thing, and accordingly forwarded everything. Now she has shown that this same game and betting, but it was shown arrest in connection with this case after a later on 13th. That is the case. That is the only case. So we call for the case diary first if there is any development here, and we record her submission that he was initially asked to appear in a game and betting case, and subsequently he got arrested in this case. That submission will be recorded and we'll pass the order and call for the case. Otherwise, we don't have anything here before us.
That I am also not getting.
My request, Your Lordship. Only one is my request, Your Lordship. Kindly give me submit one judgment copy, Your Lordship, on the last dated
No, this is the motion stays. I'm just now the question is that there are judgments. There are judgments, in fact, basis of co-accused, there is a judgment, incarceration, there are judgment, there are lots. As the Supreme Court, Honorable Supreme Court has passed a judgment of in various contexts. That is understood. And we are not on that. Exclusively on the basis of the co-accused, if nothing is there in the case there, that may be a case for bail. I can understand. But the question is now we presently don't have anything. And you brought an allegation that he was initially arrested or apprehended in the case and subsequently forwarded in the case of NDPS. That may be the position that he may not be. So we will ask the IO to say about the detail of this merit of the case. If that is the position, that is the case. And her submission will the report, order of copy of order, they already, when we call for the case diary, he received the copy of order also. Generally.
Lordship, the rejected order, Your Lordship, according to the co-accused statement, he has involved in this case. So going to be
No, we have not stated in the FIR that according to the co-accused statement. It is the investigation at the time of investigation, it has come out that he is the kingpin. That is the case, not on the basis of the co-accused.
But IO has given the case diary as per the statement of the co-accused, according to his statement.
So you have gone through the case diary also.
According to the
how can you come to know? How can you come to? It's a very serious thing. How can you come to know that IO has raised things?
When I had appeared before this court, Your Lordship, one time is rejected, Your Lordship. So on that time, Your Lordship, when I was doing the hearing, Your Lordship. So
no, I know you were there. I know. No, how can you peruse the case diary?
No, I have not.
No, you're saying that on the basis of the statement of the co-accused only police.
Yes, your lordship.
It's
According
not
to
the
the
case.
rejected order.
That is your submission.
Yes.
You go through the case or order.
Yes.
You have already submitted it on the basis of co-accused. That has reflected because
Yes.
I generally, it's my practice that whatever submission made by the council, I generally record the statement.
Yes.
I try to reflect these things.
Lordship.
Sometimes it may be at a sentence or bad, but otherwise I try to. So your submission, I have recorded your submission. Okay. Hard MSA Medi, the learned counsel for the petition. And also heard Mr. A. Busher, the learned additional VP, appearing on behalf of state respondent. In pursuant to order dated. In pursuant to order dated 20/03/2025, the petitioner has filed the additional affidavit poster. Through the additional affidavit, in the additional affidavit, the petitioner also annexed the copy of the FIR filed in connection with Sonapur PS GD entry number 20. FIR, sorry, FIR in connection with Sonapur. Sonapur PS case number 33/2025, which was registered on the basis of a GD entry. That GD entry number Sonapur GD entry number 25 dated 11/2/2025. Next para. It is submitted by MS Medi that the present accused petitioner is innocent and he is no way connected in the alleged offense. It is a fact that he was at the time of apprehending one of the co-accused in said Sonapur PS case number 33/2025. The name of the present accused petitioner was uttered by an apprehended accused. But and in that regard, he also received a notice from the concerned police. Actually, what is this? I'm just not following. What is this, in fact?
That I am also not getting any. Because
What is this, in fact? This is 33 years. Huh? No. What is this, in fact? Had already arrested. Where the arrest memo? Where is that? I don't know.
Yes.
Here it is written that team of Jonapur PS has apprehended one Nazrul Ali of Samota so in connection with under Games and Betting Act, legal action initiated. So where is if he is arrested, is there any arrest memo?
No, I have no idea.
Then how?
Then, madam,
What is
the
this? What is this, in
below
fact?
of this document? What sort of document this one?
What is this, in fact? This is what, in fact? It's a Facebook post or?
Lordship, there have a FIR also.
No, this is 33. What is 33?
Actually, this is given me by the petitioner, your lordship. According to
No, you know what is this? We are not, I'm not acquainted with all this Facebook and all Instagram. I don't have any account.
Yeah.
So I'm not aware of what is this, in fact.
This is
what is this?
I think maybe this is the message. Some messages come.
Car message. Kune dibe enuka dhoroner message kak diye kune ko? It's difficult to understand.
I think, your lordship, this is the WhatsApp message, otherwise the Facebook.
Facebook post. Huh? It is a last line to case. And one annexure has been filed along with the petition, which seems to be a Facebook post.
Lordship, Actually, we are having FIR also.
Facebook post. No, FIR I have already.
FIR also court document.
Facebook post. Post. She submitted that that after interrogating the present accused petitioner in connection with said gaming and betting case, he was forwarded in connection with the present case. And only on the basis of the statement of the co-accused, he got arrested. He was arrested. Further, she submitted that the present accused petitioner was also shown arrest in connection with Sonapur PS case number 33 of the 2025 on 13/3/2025. Thus, she submitted that is suppressing the pendency of one gaming and betting act against the present petitioner, and also he was forwarded in connection with this case with some false and concocted allegation, though he may be an accused under the game and betting act, case of under gaming and betting, which is already registered as Sonapur PS case number 33 of 2020. Next para. Mr. Busha, the learned additional PP submitted in this regard. That is, it is not within his knowledge as to whether the accused petitioner was earlier arrested in connection with Sonapur PS case number 33 of 2025, or whether he was apprehended initially under the safe case. Accordingly, he insisted to call for the case diary. Next para. Considering the submission made by learning counsel for both sides, it is seen that it is the main contention of the petitioner that he is the accused of a game and betting, which was registered as Sonapur PS case number 33 of 2025. However, he was he was falsely forwarded, he was forwarded in connection with the present case with some false and concocted allegations. It is also seen that on 17/3/2025, bail petition for the present accused petitioner was rejected on perusal of the case diary. However, considering the submission made by the learning counsel for the petitioner, let the CDB call for along with the police report as to whether he was earlier arrested or interrogated in connection with Sonapur PS case number 33 of 2025 prior to lodging of the present FIR. His report also you call for,
my lord,
whether he was earlier
lord, my
connected
lord.
and such.
My lord, a copy of the my lord additional.
Yes, copy of the order
that may
be furnished to the additional PP and the investigating officer. List accordingly. Will be after 2 weeks. It will come after BU only, otherwise we don't have any date. Yes.
2 weeks is the long day, your lordship, because the accused person is suffering diabetics also, your lordships.
What
When
to
he
do
was
now?
admitted,
Though
he was directly
60%,
taken to the hospital, your lordship.
60% people are just suffering from diabetes. What to do? See,
Kindly, lordship, give me a
he is
short.
providing with the medicine there.
Yes, lordship. And when he was arrested,
No, medicine was already provided there or in the hospital, or you need a direction.
he was admitted, I think, GMC X when he was
Further,
arrested.
further the learned counsel for the petitioner submitted that the accused petitioner is a diabetic patient. The jail authority is accordingly directed to provide required or necessary treatment as needed by the accused petitioner. Send a copy of the order to the superintendent central jail. Guwahati, he is in Guwahati or?
Yes, Guwahati.
No, in which place he is, detained?
Central
Which jail he is
Guwahati
detained?
Central Jail.
Guwahati.
Central Jail.
Sir, superintendent, central jail, Guwahati. List accordingly. Yes, Professor, when it can be listed.
Okay.
Madam, 10th of April, madam.
Let's see, 10th of April.
10th of April is so much longer, your lordship.
10th of April, we are listing it up. Yes.
For admission until 14th.
Petition, my lord. Against an order of the family court, my lord.
Huh? Order of?
Of the family court, principal judge family court.
Acha, family court.
Yes, passed in a maintenance case, my lord.
Yes.
So, my lord, in the maintenance case, my lord, the order was passed, page number 23, my lord. Page number 23, 21/9/11.
No, 23 is different thing. What is 20? Oh, it's an order.
Yes, my lord, maintenance order, my lord. 21/9/2011, my lord.
2011.
11, my lord. There was an order, actually this order was passed ex parte, my lord.
Order passed ex parte.
Ex parte, my lord. The petitioner husband and the respondent wife are residents of Tripura, my lord. So, my lord, during the pendency of this maintenance petition, the petitioner was for earning his livelihood. He was staying abroad, my lord, Kuwait.
During the pendency of this case.
Yes. This is, and this is admitted, my lord, that he earned his livelihood in Kuwait. Another fact is that, my lord, this respondent wife is the second wife of the petitioner, my lord. There was earlier, the first wife, he had married in the year 1993, my lord. And there was no issue. And with the consent of the second wife, present wife, he had, no, my lord, after the first wife, he married the second wife in 14/3/2002, with the consent of the first wife. The present wife is the second wife, 14/3/2002. Two girl child was born out of the second wife, my lord. One in the year 2002 and another 2005. From the side of the second wife, my lord. So disputes arose, my lord, in the year 2006, when the petitioner returned from Kuwait and the first wife was with him in Kuwait, my lord. Then, my lord, this respondent wife filed an 498 case against the petitioner and his family members, my lord, in the year 2006. In that case, my lord, in 2013, all the petitioners, all the family members of petitioners acquitted. I have annexed the judgment, page number 14, my lord.
So you are agree with the maintenance order?
Maintenance. During that period, my lord, during that period, in 2009, she has filed the maintenance case, my lord. 4/8/2009. So what happened, my lord? I have annexed, my lord, some documents of the payment. The maintenance order was, my lord, payment for 4,000 to the respondent wife and 3,000 to the daughters. Page number 24 is the, my lord, operating department. Your lordship. Page number 24 of the maintenance order. 4,000 was for the wife and 1,500 each to the daughter. That is 7,000. That was the order of 2011, my lord. At that time, the petitioner was, my lord, staying at her maternal house. And after that, my lord, from 2012 to 2018, these 6 years, the respondent wife lived with the petitioner, my lord. That is important, my lord. From 2012, that is after the judgment in the maintenance case passed, she returned back to the petitioner's house and lived peacefully from 2012 to 2018, my lord. 6 years. So she did not file any execution petition for this maintenance amount. She lived peacefully. And my lord, during that period, on 11/1/2016, my lord, page number 32. Page number 32. An amount of rupees 10 lakh, 5 lakhs and 5 lakhs, my lord, page number 32, was transferred by the petitioner in the account of his mother, Nyoti Rani Das. Nyoti Rani Das is the mother, my lord. Page number 31 is the other card, my lord. Mother of the petitioner. It is not disputed, my lord. It is
I
not
mean, 10 lakhs was transferred?
transferred in the mother's account of the petitioner, my lord, for the respondent wife. And that is, my lord, in same annex 32.
No, 10 lakhs was deposited in whose account?
Mother's wife, petitioner's mother wife, my lord. For
Petitioner's?
mother's.
That is his mother-in-law.
No, mother's account.
Your mother, her mother-in-law.
Mother-in-law, yes. To transfer to the respondent wife. That is reflected in page number 32, my lord. After 3 days, it is transferred. After 3 days, it is transferred, my lord, page number 32. My lord, on 14/1.
Why directly not?
But because she had no account, my lord. She opened her account on 13/1. Next page, my lord, 33. I have annexed the passbook, my lord. On 13/1, she opened a account, my lord. So, my lord, on 14/1, the said amount is transferred to the account of the respondent wife, my lord. Page number 32, it is mentioned, my lord. And my lord, page number 33, on 1/2/16, after a few days, my lord, 1/2/16, the petitioner again transferred an amount of rupees 1,10,000 directly to the account of the wife. Page number 33, my lord.
What is the amount?
My amount 1,10,000. Page number 33 mentioned, my lord, 1/2/16 directly because she opened an account in the State Bank of India. So 10 lakh and 1 lakh, my lord, 11,10,000. And that 10 lakh, my lord, your lordship will find page number 34, fixed deposit in the name of the wife, my lord, for 3 years term, my lord. That is already matured in 2018, my lord. And that amount is already withdrawn, my lord. So, my lord, petitioner's claim is that, my lord, he had already paid more than 12 lakhs of rupees, including this maturity amount and 1 lakh amount, to the petitioner wife, my lord. So suppressing all these, my lord, the petitioner wife filed the execution petition, my lord, on 27/9/18. And in the execution case, my lord, the honorable court issued warrant of arrest, my lord, because the non-appearance of the petitioner, because he did not know that execution case was filed and it is going on, my lord. It was not informed, my lord. At that time, he was abroad, my lord. And lastly, my lord, he received the notice to the ambassador of the Indian ambassador, my lord, and then he returned and approves this honorable High Court, my lord, page number 44. Page number 44, this honorable court's order, my lord, against the issue of warrant order, my lord. Claiming all these, my lord, payment 45, page number 45. Second paragraph, it is mentioned, my lord, all regarding the payment. And this honorable court directed the petitioner to approach the honorable family court and place his case, my lord, regarding payment and by supporting document, my lord. Accordingly, this petitioner, my lord, approached page number 47 with a petition, my lord, as per honorable this honorable court's order, my lord.
Page number?
Page number, my lord, 47 is the application, my lord.
What was the prayer here?
Well, a prayer, my lord, to recall the warrant of arrest, my lord.
That
And
has already been recalled, I think, by the High Court.
High Court, my lord, till the next date, my lord, 12/4/19.
One prayer is for recalling, another prayer.
Another prayer, my lord, to drop the proceedings, my lord, because he has already paid, my lord, the amount after perusal of the documents, my lord. So this petition was, my lord, fixed for objection, and my lord, the respondent wife filed the objection, my lord, page number 52. Page number 52, my lord. Then, my lord, the petitioner again filed an application pending this application, my lord, that after deducting the amount, my lord, the remaining amount may be refunded to the petitioner. It was a petition page number 61, my lord, of the petition.
No, what is 52? They
It
reply.
was pending, my lord. Objection, my lord. Yes, reply. Their reply, my lord. 52. In the my application of recall, my lord. Then pending this petition, the petitioner again filed it 7/1/2020, page number 61. Another petition, my lord, praying for refund of the excess amount, my lord, after deducting all the maintenance amount, arrear and present. And both these petition was pending, my lord. Then, my lord, the COVID period came, my lord, to which the respondent also filed objection, page number 67.
No, 61 is
61
the
is the
application filed by her.
By the petitioner, my lord.
Why? By the petitioner.
Husband, my lord, praying
Acha.
for refund of the excess amount after deducting the maintenance amount, arrear and present, my lord. To which the respondent wife, my lord, submitted an objection also. Page number 67, their objection, my lord. And pending these two petitions, my lord, there was a COVID period, my lord, and the case was not proceeded, my lord. Subsequently, my lord, after COVID period, my lord, the case again proceeded, my lord, but without passing any order on both the petitions, my lord. That is the impugn order, page number 84, my lord. The honorable court issued notice for payment to the petitioner without passing any order on the pending applications, my lord. Page number 84 is the impugn order.
84.
84, my lord. 84, my lord. So the grievance of the petitioner is that, my lord, as per earlier order, my lord, this honorable court, my lord, the petitioner appeared and submitted all the documents, my lord, of payment of an amount of more than 12 lakh, my lord, to the respondent wife, my lord. And pending these two petitions, my lord, without deciding the petitions regarding, my lord, the claim of the petitioner payment of the family court again proceeded, my lord, for payment of that is the grievance of the petitioner.
So whatever, your monthly maintenance, you have to pay monthly maintenance
7,000.
only 7,000.
7,000.
So you are not paying a penny now.
Not paying, my lord, not paying. But my lord, the
What to
petition
say?
is pending, my lord. Whatever earlier this honorable court, the petitioner, my lord, approves by all these documents, this honorable court showed, my lord, regarding the
So
50.
do you think that till your disposal of your petition, both petitions definitely it has to be disposed of, I won't say.
Yeah.
But your entire proceeding should be stayed, or there should not be any order of payment. What to say?
My lord, at this stage, my lord, my prayer is that, my lord, let the honorable family court, my lord, decide the petitions, my lord.
No, here instant petition. What is your petition here before this court now?
Before this court, just, my lord, page number 12, my lord. Page number 12 regarding, my lord, the again, since warrant is issued, my lord, to recall the warrant, my lord, of arrest, my lord. Page number 12. Because it again went to the earlier stage, my lord. Earlier stage when the petitioner approached this honorable court, my lord. The case again, my lord, taken to their stage, my lord. The family court did not decide, my lord, whether the petitioner had to pay or what will be his amount already paid to the respondent. All these issues not decided by the executive court. So let the court decide, my lord, on these points.
Yes, some time may be granted because for further instruction from my client.
Huh?
Some time may be granted for further instruction from my client because I have not been able to connect with her.
So he is submitting since long, and why you're keeping silent? The other case, of definitely other cases will be adjourned for your silence only. If you require time, you could have raised the matter earlier. He submitted all along entire things, and then now you're saying that you want some time. What instruction do you want? Otherwise, you have the instruction. What other instructions do you want?
Regarding they have filed the affidavit in this case.
You have already filed your affidavit. Now issuing DW, suppose, or distress warrant, I don't think it will serve the purpose because same report may come that there is movable, non-movable. So why don't you come and do an amicable settlement? Suppose he is with a case that he has already paid more than 12 lakhs during that period from 2000.
From 2012 to 18.
But you are not claiming 2012 to 2018. 2012 to 2000 when you were there with him, but she has not claimed that one. The entire period of 2012 to 2000, she is not claiming.
My lord, the execution is from the date of the order, my lord.
But the question is that during question 12 to 18, suppose you are saying, and it is an admit question, that she was with you. So whatever maintenance you provided during that 6 years, it is not out of the case, but it is from your settlement, you are staying together.
Yes.
So how it can be considered as a area payment because she is not claiming at all that period.
Yes.
That is there, isn't it?
All that issues may be settled before the honorable family court, my lord. That both the party appear, my lord, that date may be given by
Regarding recalling, what do you want to say? Suppose matter was already once before this court, wherein the NBW was recalled with a direction that you appear before this so and so. In that case, he appeared with a petition. That petition was kept pending, and thereafter subsequent another petition was also filed with some prayer. And in both the petitions, you have already filed your objections. So now a recalling will affect you, or what do you want to say? Submit anything. Or you want to ask? Now the simple question is that they, sending the DW or even NBW will not serve the entire purpose. Question is that, but you're not claim, and that's why I'm saying that even 12 lakhs had been paid. That may not be included in the area amount because that period you're not claiming at all. So you have filed your whatever after 18 only. So whatever will come definitely after 18. Not in between, they will not come. So if it is area amount is already there, you have a good case. If area amount is there, those 12 lakhs may be deducted by the court, may not be also. That is because it was mutually you were there, you were staying together, and in that period, some money was paid in your account. But the question is that by sending DW or distress warrant, whether it will serve the purpose, that's what I must. If you want further clarification, then okay, then we'll keep it in some other day. Know what to do.
Your DW may be cost. But regarding the.
It was the only prayer, my lord. So the matter remanded to the family court to decide whether he is entitled to that.
So we'll do one thing, we'll not issue any stay and all. Stay would dare not be there because in a maintenance case, generally we do not pass any order on stay. There will be entire matter will be decided by the court if there any area amount was already paid, suppose, as they have claimed. That can be done, I think. And those two petitions which were filed on one on
12/4/19, my lord. And another one 7/1/2020.
No, one was on
12/4/2019, my lord.
Just a second. One was on 12/4.
12/4/2019. And second 7/1/2020.
7/1. 2020.
Yes.
And in both the matters, they have filed already, objection is filed. And the High Court's order was, this court order was on page 44 when it was passed?
My lord, it was passed on 5/4/19.
5/4/19. Thereafter, you approach with a petition.
Yes, as per direction of this honorable.
You are Mr. Kadi?
Yes.
I heard Mr. M.J. Kadi, the counsel for the petition. And also heard you are? You are Mr.
K. Dev on behalf of B. Deca.
K. Dev on behalf of B. Deca. K. Dev appearing on behalf of Mr. B. Deca, the learned counsel for the respondent number 2, and also heard Mr. K. Bosher, the learned additional PP appearing for the state respondent number 1. This is an application filed. New active file or
Earlier,
old?
21
matter.
Yes.
Filed under section 482 CRPC for recalling of DW/warrant of arrest issued against the petitioner in execution bracket of criminal case number 4/2019 arising out of FC bracket of criminal case number 390/2009 passed by the learned principal judge family court Kamrut Guwahati on 25/01/2021. Expera. It is submitted by Mr. Kadir, the counsel for the petitioner, that that the present respondent is his second wife, and she filed a case praying for maintenance before the learned principal judge Principal Judge Family Court, Kamrup M, and the order for maintenance was passed on 21/09/2011, which was passed exporting, directing the present petitioner to pay rupees 4,000 per month towards the maintenance of the respondent first party and rupees 1,500 each to to both his daughters. That is in total 7,000 per month. However, full stop. As case was decided ex parte as during dependency of the case, he was working in Kuwait to earn his livelihood and the livelihood, full stop. Full stop. Next. So further, he submitted that prior to lodging of the maintenance case, the respondent also lodged a case under section 498A IPC against the present petitioner and his family members, but he and his family members got acquitted from the said case in 2013. But after passing of the order of maintenance, the respondent again went back to her matrimonial house and stayed along with the present petitioner from 2012 to 2018 and 2018, and thereafter she left her matrimonial house and filed the case for execution. But she did not claim any maintenance. She did not file for any execution of the maintenance maintenance allowance for the said period, that is 2012 to 2018. Mr. Qadir further submitted that during her stay along with the present petitioner, he paid more than rupees 12 lakhs, which were deposited in her account initially through the account of his mother and subsequently directly on her account. On 27/9/2018, she filed the execution petition claiming for area maintenance and then the present, and in that case you were issued not NVW again?
Yes.
DW.
Earlier, yes. Earlier.
And without considering any aspects of the case, the learned Principal Judge Family Court had issued DW against the present petitioner, and for which he approached his court for recalling of the NBW/DW, and by order dated 5/4/2019, he was directed to, if the NBW was recalled, and he was directed to appear before the learned trial court below with appropriate application. Accordingly, he filed an application on 12/4/2019, praying for recalling of the NBWA and dismissal of the maintenance case, to which, the respondent also filed their written objection. Subsequently, again on 7/1/2020, he filed another application for refund of the excess amount which has already been paid to the respondent. Full stop. To that also, the respondent filed their objection. But without disposing those two petitions filed on 12/4/2019 and 7/1/2020, the learned Principal Judge Family Court passed an order on 25/01/2021 directing
Page 84, man. Page 84, man.
even now director issuing the DW obliques warrant against the present petitioner. With the observation that he had violated the order of this court dated 21/09/2011. On being aggrieved to the said order, the present petition has been filed for praying for recalling of said DW and to dispose of the two application and to recalling this so and so and to pass necessary order. Mr. Dave, yeah. Mr. Dave appearing on behalf of the respondent number 2 submitted in this regard that there is. So you denied that regarding the payment of 12 lakhs. You denied.
It was
You have written on the facts of the case. Facts we do not need us actually. Because against the facts, he has not come before us.
Page number 45 of their affidavit, last line, my lord.
Submitted that the petitioner is intentionally avoiding from paying the maintenance allowance as well as the arrear amount. And it is also stated that the payment of rupees 10,11,151 to the petitioner has no remote connection with the payment of maintenance. Maintenance, full stop. So you denied that you are staying with him from 2012 to 2018. So you have claimed the maintenance for entire period or what?
Your lordship, can please go to page number 55.
55.
Page 55.
55 we don't have.
53.
Page number 55 we don't have.
Next 11 petition. Annex 12.
Petition, madam.
Petition.
Petition.
Oh.
Petition.
Petition number 55.
Annex 12. Page 4. Page number 4. Your lordship, in the month of January 2016, para 6. 7th line.
Yes.
In the month of January 2016, the mother-in-law came to the rented house and lamented for the entire episode. She told that the money has been deposited on her account just for the education purpose of her grandchildren, and it has no so it has no connection with the maintenance.
No, just okay then. But I'm saying that that the petitioner's story that he was, you were staying with him from 2012 to 2018, whether you admit this part or you're not admitting?
No,
Again, on that part only. You admit.
no. I was not staying.
You were not staying with him. No remote connection, is no? Further, it is stated that the respondent also denied to her objection that she never stayed with the present petitioner from 2012 to 2018 as claimed by him. From the entire period, he did not pay her maintenance, and for which there was a huge error maintenance amount. And still now he is avoiding payment of maintenance as well as the arrear amount. Next part. Considering the entire circumstances of this case, it is seen that after the order on, but why you have remained silent and did not claim any exit money for
7 years.
till 2007 years? If you are saying one hand, you are saying that you are now staying with him. So if it is true, then why are you sitting for 6-7 years without any money? You are sitting. It is quite surprising also. If you don't have any source of income, if you don't have anything, then why are you waiting? Because order was passed on 2011 itself. That was also an ex parte order. Thereafter, he waited till long 2018 when you filed your execution petition. Next time, key set of it. It is seen that the marriage between the parties and the paternity of the children are not disputed, and it is also not disputed that the order of the order was passed ex parte in the year 2011. However, though it is claimed by the petitioner that she was staying with him for entire 2012 to 2018, and 2018, and hence she is also not claiming any execution during the same period. However, it is disputed. However, it is denied by the respondent side, and it is her claim that she never stayed with the petitioner from 2012 to 2018 in her matrimonial house. But it is a fact that she did not claim for any maintenance, and execution was filed only in the year 2018. There is no proper explanation as to why she waited since long 6 years to file her execution, though the order of maintenance was passed in 2011. Further, it is also seen that after order passed by this court, the petitioner approached the learned principal judge family court with 2 applications as stated above, but have a state application, and the petitioner and the respondent also filed their written objection. But till that, those petitions are not being disposed of, though the order of issuing DW and warrant was passed by the learned principal judge, filed its impugned order dated 25/01/2021. But in the but in the same time, it is also admitted that the petitioner is not been paying any maintenance to the petitioner and her daughters, or to the respondents and her daughters, though it is claimed that he has already paid more than ₹12 lakhs during the period from 2012 to 2018. So, in view of this, I find that the learned court below, or the learned special judge, Uh, can hear the petitions, and is to be and also it is to be decided regarding the maintenance regarding the maintenance claim from 2012 to 2018, and to pass necessary order in this regard. However, considering all the aspects of the case, the NBWA the DW issued against the present petitioner is hereby recalled with a direction. Do you know when the next date is fixed?
Stayed, my lord.
Huh?
It is stayed, my lord. Proceeding.
Stayed. It is a recall. Stayed, however, but the stay order is there
Yes,
also.
first order, my lord.
First order dated. First order was passed on 21. It is the direction to both the parties to appear before the learned principal judge family court on or before after Eid or Bihu after Bihu will do after Bihu ke baad
On
date
23rd, my lord, on 23rd.
23rd of April 2025, and the learned special judge family court also will hear the petition as referred above and will pass necessary order in that regard. However, the petitioner is for necessary order in regards to area amount of maintenance. However, the petitioner is directed to pay the maintenance allowance till any order is passed by the learned principal as well. Disposed of copy of the political petition. You were asked to appear before 23rd of so and so.
On 23rd.
23rd
April.
April. Positive.
Obliged.
Stay vacate corridor. Stay order. That's again. Stand vacated.
Obliged.
One more. Yes, 17. Yeah, for the petitioner.
I'm for the petitioner, Lordship. Lordship, this is a 482 petition, and before coming into the factual matrix of this case, the whole case, my ground here for seeking the quashment of the said proceedings before the learned trial court is on the basis of the abuse of process of law. Because the whole case revolves around that, and the matter arises from a financial transaction between two persons. If Lordship would come to the FIR, which is at running page, my lord, at page number 24, that is annexure number 1. Annexure number 1. This is the type translated copy of the FIR. This is the FIR. It was being lodged by one Motuzali. If Lordship may maybe if Lordship allows me to just take to the relevant part of the FIR, because it's a long one, so I would take to the relevant part only. And the relevant part is, my lord, that the informant respondent number 2, Motus Ali, stating inter alia therein that he had a joint family business under the name and style of Farjina Enterprise dealing in broomsticks, charu flowers, etc. On 9/4/2021, one Shri Sanjeev Saha son of late Nani Gopal Saha, being one of his business agent, had contacted the petitioner, Sri Krishna Dev, for bulk supply of broomsticks from Dengaon in the district of Karbi Angle, Assam to Gwalpara, which the petitioner had readily agreed. Later, said Sri Sanjeev Saha, after negotiating the price with the petitioner for supply of the said broomsticks, informed back respondent number 2 Motusali regarding the same. Thereafter, on 9/4/2021, informant respondent number 2 had rented a 12-wheeler truck bearing registration number so and sent the said truck to Dengaon for bringing the broomstick as per the contract arrived it with the present petitioner. Basically, Lordship, there was an oral contract between the two persons for purchase and supply of broomsticks. Basing on that, on 10/4/2021, the broomsticks were caused to be loaded upon the said truck, and after that, the said truck got fully loaded and handed over the necessary transit documents along with all the necessary documents which were required for mobilizing the said bulk supply of the materials from one place to another. Accordingly, the informant respondent made a payment of rupees 10 lakhs to mobile internet banking system. And thereafter, it was the allegation of the informant respondent number 2 that after payment of the said amount, rupees 10 lakhs, the petitioner immediately fled from the scene, keeping the mobile phone switch off. Consequently, the informant respondent number 2 had to unload the said truck. In such situation, FIR was lost and was received as Gwalpara PAPS case number 316/2021, and accordingly, charge sheet was submitted by the investigating authority. During the course where the petitioner was arrested, my lord, petitioner was arrested. If my lord would come to the pleadings part, that is on para number 6, page number 11. This is the, if I will be allowed to read the said paragraph. In paragraph number 6, that it is respectfully stated that on 26/11/2021, the petitioner was arrested and then forwarded to judicial custody in connection with the said Gwalpara PS, case number 316/2021, corresponding to GR 1088/2021. Furthermore, it was respectfully stated that while the petitioner was languishing at jail hazard, one John Islam, who happens to be an agent of the respondent number 2 informant, filed the petition under section 439 CRPC before the learned court of session judge at Gwalpara. And interestingly, the respondent number 2 filed the petition along with affidavit to the learned prosecutor Gwalpara stating that the matter between the informant and the accused, that is the petitioner, my lord, has been settled down. As such, he would not have any objection if the accused, that is the petitioner, was enlarged on bail. Situated thus the learned court below, after perusal of such petition and having found the affidavit of the respondent number 2 informant in the case diary, prima facie showing that the matter has been amicably settled between the petitioner and the informant, the learned session court was pleased to enlarge him on bail. The annexures 7 and 8 and 9 are the copy of the bail order, my lord, copy of the petition and the affidavit. From the case diary itself, my lord, the affidavit was found where it was stated by the informant that the matter between them was settled. Consequently, my lord, in the event of the matter being settled between both the parties, the petitioner and as well as the informant and respondent number 3, who the respondent number 2 claims to be one of the authorized person of the respondent number 3. In the charge sheet portion, if lordship would come for a moment in the charge sheet portion, the charge sheet is at page number 53, that is annexure 10. They have annexed one copy that is at page number 55, that is the power of attorney, on basis of which the said person was said to have been authorized by Farzina Yasmin Ahmed, that is the respondent number 3, to regulate, maintain all the banking accounts and everything. But here in the second page, that is the 56, page number 56, lordship would file the signature of the attorney holder is missing. This is prima facie over the said records. On the face of the record, this thing has to be taken note of, man. On basis of this, the said investigating authority has filed its charge sheet. Now, my lord, when it comes to the basic crux. As earlier I have submitted before your lordship that the matter which happened to be arising out of the financial transaction, now they once have amicably settled the matter. Again, they go that the matter is not settled. The investigating authority filing is the charge sheet. So on that ground, my lord, I have sought for quashment of the FIR. And apart from all, over and above, my lord, if lordship will come to paragraph number 9 of my petition, I have made the averment here as how both the sections are not attracted at all. In this case, this is my second ground. Apart from the abuse of the process of law, this is my second ground, wherein I have taken the stand that 406 and 420 IPC is not attracted at all in this instant case before your lordship. Because here, mere allegation to the extent of the petitioner left the place after loading the truck, keeping his mobile phone switch off, is not at all sufficient to attract offense under section 420 IPC. Moreover, the informer has not stated in the FIR at what price the entire deal was struck between the accused petitioner, and if the payment of the deal was not paid, the accused had every right to retain the truck. This is my second ground which I am taking. And over and above, I have also taken grounds from paragraph number 10, the grounds on basis of which this FIR was registered spontaneously, moreover, without the application of mine as such, therefore it is liable to be quashed. Accordingly, all consequential proceedings, my lord, arising out of it. Because, my lord, once they will say we have settled, they file a affidavit, case diary prima facie reveals that there is an affidavit, there is an observation made by the learned session judge, my lord. Again, they will file one charge sheet. This amounts to harassment, this amounts to abuse of the process of law, my lord. So on that grounds only I am seeking for the such reliefs, my lord. And the apex court, my lord, time to time has been reiterating that the abuse of possessive law can be the sole ground, my lord, for quashment of an proceeding, impugn proceeding, my lord. This is my submission.
In this case, I appeared on your instrument number 2 and 3, Malak. What had happened in this case, Malak, he not only once but 2 times he cited the petitioner, instrument number 2 and 3. But on the basis of the negotiation in between the agent of the present instrument number 2 and 3 and the petitioner, there was a deal already has been negotiated that broomstick has been supplied by the petitioner. On the basis of that, the present petitioner sent a tract on 9/4/2021. After reaching the place, the petitioner took up the truck in a godown and loaded the truck. Thereafter, a photograph has been sent to the respondent number 2. He was at that point of time in Kolkata. And after sending this photograph, he demanded the remaining amount. Then the respondent number 2 deposited an amount of rupees 10 lakhs in the account of the present petitioner through internet. After depositing, the petitioner fled away from that godown. And broomsticks which loaded with the truck, when the driver moved out the truck from the godown, the original owner of the godown has come out. He said that without the payment of the amount, you cannot move the truck from here, or otherwise you unloaded the broomstick. And driver having no other option, he contacted with the respondent number 2 Then respondent number 2 tried to contact with the petitioner. The petitioner mobile was switched off. He could not contact it with the petitioner. Then the broomstick unloaded there in the godown and the empty track has come up. As regard the transit permission is concerned, Your Lordship, if you go through the records, my lord, it will reveal. He obtained the transit permission from the forest department just to show to the driver or to show the respondent number 2 that he have already taken the transit permit to taken the broomstick from the godown to the Walpara. But after loaded, the transit permit has not given or handed over to the driver. He taken out this and submitted the original one before the forest office. That was revealed from the FIR. Learned friend has not submitted before Your Lordship. He also filed an FIR against the present respondent number 2 and 3. What had happened? Then on the next day, that is on 11/4/2021, the respondent number 2 went there to charge the petitioner and contacted with him. What had happened? But he could not contact it and then returned back. And then he immediately filed an application before the concerned bank, where the account of the respondent number 2 and 3 is there, to freeze the account of the petitioner because the amount he could not have been withdrawn because the broomstick has not been given to him. Thereafter, the petitioner waited for some days to contact with the petitioner but could not do so, having regard to that, then filed this FIR before the Gwalpara police station because deal was there in Gwalpara. Then Gwalpara police went there to charge the petitioner but could not arrest him, then returned back. And thereafter only the petitioner lodged an FIR, kindly see page 34 of the petition. This is the FIR lodged by the petitioner itself. And this FIR has also been registered and subsequently transferred to the Gwalpara. And this FIR was renumbered and investigated both the FIR by the Gwalpara police. And subsequently, Gwalpara police has filed the final report in the FIR lodged by the petitioner. And the FIR lodged by the respondent number 2 has filed the charge sheet. And on the basis of this charge sheet, he was arrested. Before the charge sheet, he was arrested and taken to the Gwalpara. Then he all sent the agent to the respondent number 2 by saying that after come out from the court, jail, then he will pay the entire amount and will settle the matter. On good faith, this affidavit has been filed by the respondent number 2 before the learned session judge, Gwalpara. But just after come out from the jail, he again pleaded. This is the actual picture, man. This is the actual fact. And if Your Lordship go through the entire record, I think record has come, man. The entire things will be revealed that the transit permission we see shown in this petition, manner, this is in photocopy. An original one is written back. And on the basis of the FIR itself, there is a prima facie case against the petitioner. Your Lordship knows regarding the judgment ballot of the Bhajanla and others, where the guidelines has already been formulated by the Honorable Supreme Court. And on the basis of that guideline ballot, these FIR as well as search sheet does not come under the purview to quashing or interfere by this Honorable Court under Section 482. And beside this, another so many judgment of the Honorable Supreme Court is there by saying that if there is a disputed allegations, then that has been decided by the trial court. The interference should not be made in the midst of the investigation or at the time of trial. Since the FIR as well as the search sheet clearly reflected the offense committed by the petitioner. So at this is just my humble submission, and the guidelines, as per the guidelines of the Bhajanla's case, this case does not come under the purview for interference by this Honorable Court under Section 482. My humble submission before Your Lordship that this criminal petition is liable to be dismissed and the trial may be continued. This is my humble submission.
So far as for the said judgment which has been referred by the respondent or the counsel for the respondent, Bhajan Lal, even in that judgment also, my lord, abuse of the process of law, that is also an held a precedent which courts has to follow while examining any case when sought for quashment in the section 482. And my lord, 482, as its language itself suggests, saves the inherent power of the court, which it has by virtue of being the superior court to prevent the abuse the process of any court or otherwise secure the ends of justice. And moreover, my lord, the stand which they have taken, the respondent side has taken, is regard as to their averments which they have made in the affidavit also, was regard to the happenings or which might have taken place at that particular relevant point of time before filing of the FIR. But after filing of the FIR, once if it is stated, the matter is settled. Again, they say that the matter is not settled. The process has to go. Whether the present law allows such stance, that is my humble submission before this honorable court. And for all the submissions and all the grounds which I have taken in paragraph number 10, my lord, of my criminal petition, my lord, that is at page number 15, all the grounds, my lord, all of the grounds, my lord, I have made a good case for quashment of the said impugned proceedings, which is pending before the learned trial court, my lord, which is my humble submission. And as well as, my lord, the copy of the attorney also, my lord, will be pleased to take a look on that, because they file one petition or maybe an application before the concerned bank authorities for freezing the amount. But that part is something different. Whether any pendency of a criminal case would amount to freezing of the bank accounts or not, that is a separate thing, my lord. But here, the signature of the attorney, that is missing. The investigating authority, my lord, they have.
Through whom that, who was the, the attorney holder?
My lord.
Attorney holder?
My attorney holder was the informant, informant, that is the respondent number 2, my lord. He claimed to be the authorized
in the
person
petition which supplied
of
to
the
me,
said respondent
place is
number
missing.
3, who claims herself to be the owner of the said enterprise. Now, respondent number 2, my lord, he says that I am the attorney holder. I am the person who is authorized to look after all the bank accounts. And at that time, they file one FIR, they go before the investigating agency, they show all the documents, and now they come up with one copy of attorney where his signature is itself missing. My lord, this is something which is not disputed.
In that case,
This
my
is
lord,
something, my lord, which is not disputed.
in
It
this-
is
in this-
prima
in
facie
this-
on the face of record. Earlier, I have submitted.
Well, in this petition, now I have get my lord, the supplied to my learned friend, only page 54 is there. And this attorney, power of attorney is not in my petition. We supplied to him.
It's not supplied.
Not supplied. Because the petition I have received through the post office. And after receiving this petition, my lord, I have prepared, but I have gone through the same and filed the affidavit. But these 2 pages regarding the power of attorney is not there. Be that as it may, my lord, this is the case whether the FIR as well as the search sheet can be quashed or not. In that, my lord, I have relied upon the Bhajanla judgment, para 102 and 103. My lord. Para 102 is very clear. The guidelines, there are about 7 guidelines has been formulated on the basis of that. And since the police has thoroughly investigated into the matter and finally submitted the charge sheet and the allegation leveled by the petitioner and laws and FIR, this FIR has been submitted the final report by the police. And after perusal the records, your lordship will find the everything will be clear. And this is not a fit case for interference under section 482 by this honorable court. This is my humble submission. The citation of the Bhadanlar is 1992, supply 1 SCC 33.
Because power of attorney, you have not filed by through an additional affidavit also. How it was missing from their copy?
Maybe in the
Have you
submit
annexed
copy,
subsequently?
That's why, my lord.
might have maybe missed.
Miss means?
This copy, there it is in my record also, I have, but while serving them the copy, if I would allow them to supply one fresh copy, then
This is what you say, but the not
Nail.
file. Order is out.
Bhadanlar.
highly approved.
Item 20.
Item 20.
May please lordships. This is
You are for the
application
respondent.
I'm for the respondent number 2 and 3,
in this case, my lord, way back in the year of my lord, 2022, my lord, and motor vehicle accident took place, my lord. As a result of the said vehicular accident, my lord, the son of the respondent number 2 and 3 were died, my lord. And my lord, thereafter, my lord, the respondent number 2 has lodged an FIR, my lord, and accordingly, the PS case has been registered. My lord, immediately after registering the case, my lord, the matter was, my lord, the respondent number 2, my lord, respondent number 3, as well as the petitioner, my lord, they are almost the resident of the almost same localities, my lord. And immediately after registering the case, my lord, the matter has been amicably settled, my lord. And they have informed my lord, they have approached the officer in search of, my lord, police station to withdraw the case, my lord. My lord, as the matter, my lord, as the case has been registered, my lord, but that has not been, my lord, taken into consideration. And subsequently, my lord, case has been charged against the petitioner, my lord, that is the accused in PS case, my lord. And hereafter, my lord, case has been now, my lord, is pending before the learned Chief Judicial Magistrate, my lord, Borpeta. As a PRC case has been registered, my lord, under section 279 and 304 A IPC, my lord. Now, my lord, we have, my lord, filed this petition for quashment of the proceeding, my lord. In this regard, my lord, the respondent number 23 also appeared, my lord, and already they have filed, my lord, respondent number 2 have filed, my lord. They have no any objection in this regard, my lord. And matter has already been, and they are, my lord.
Stage of the case at present.
My lord.
Stage of the case.
Stage, my lord, appearance, my lord.
Still in the stage of appearance.
Appearance, my lord. But in this regard, my lord.
No, case is still appearance stage.
Yes, my lord. In this regard, my lord, this honorable court, my lord, your lordships has already passed a similar nature of, my lord, order in, my lord, criminal petition number, my lord, 310/2024. And my lord, our High Court has also passed some other judgment and orders, my lord. I am placing those judgment, my lord. One case in which your lordship has passed order, my lord,
by quashing the proceeding, my lord, in PRC case, my lord, that was registered under section, my lord, 279 and 338 IPC. My lord, that proceeding has been quashed by your lordships, my lord. And my lord, in another case, my lord, in my lord, criminal petition number 992/2023, my lord, 992/2023, my lord. In this case, by this honorable court, my lord, the case has been, the proceeding has been quashed, my lord, by and section relates in the said case, my lord, that is 279/304A, my lord. My lord, because only on the sole ground that, my lord, the if the proceeding will continue, my lord, then there will be nothing, my lord, then only the matter of abuse of the process of law, my lord. As the matter has been amicably settled, my lord, and there is no any chance of any conviction even, my lord, as because they are not intended, my lord. In fact, my lord, respondent number 2 and 3 are not intended to proceed the case, my lord. And my lord, in another case, my lord, that was passed in, my lord, 2019, my lord, in criminal petition number 596/2019, my lord, that case relates to section, my lord, 279 and 304A IPC and 427 IPC, my lord. My lord, your lordship is very much aware, my lord, has already passed so many judgments of like nature, my lord. That's why, my
Yes,
lord.
you have already filed your affidavit.
Yes, my lord. I have no objection, my lord. Matter has been amicably settled between the parties, my lord.
The 2% that, my lord, in this accident, my lord. Now, whether, my lord, the recent negligence driving was there or not, these are a matter of trial, my lord. Now, my lord, they have compromised the matter, my lord, they are being the informant, but, my lord, police has investigated the matter and police has filed a search sheet, my lord. Now, my lord, when police has filed a search sheet, my lord, whether, my lord, due to compromise between the parties, my lord, can it be, my lord, compounded, my lord? Ultimately, they are paying for compounding the offense, my lord. That has to be looked into, my lord. That is my humble submission, my lord.
But, my lord, in 482 petition, my lord, whether we have to look into the matter, that whether there is any chance of conviction or not, my lord.
No, that
And
the
if
trial
there
will
is,
decide,
my
my lord.
my
Conviction
lord,
is, the trial will decide, my
if there, my
after
lord,
recording the evidence of the witnesses.
if there, my lord, there are the hundreds of judgment, my lord, passed by this honorable court as well as the, my lord, Supreme Court, but in Lakshmi Narayan case, my lord, also in Bhajanlal case also, my lord, such kind of cases, my lord, they are quashing. As because, my lord, there is no any chance of conviction, and there is only the mere abuse of the process of law only, my lord.
No,
That's why-
informant is not the eyewitness of the incident, my lord. My lord, who will be the eyewitness? Who will be the probable witness? These are the, my
But-
lord, other passengers, my lord. So I'm sorry, my lord, other witnesses who were at the time of present in the road, my lord. They will only probe the recent negligent driving of the, my lord, accused person, my lord. So informant is, informant is the, my lord, father of the, my lord, one of the deceased person, my lord. So he has not witnessed the incident, my lord. So how he will prove before the trial court, my lord, whether it was a recent negligent driving of the accused person or not?
No, I am not.
It will be, my lord, it will be proved by the other, my lord, witnesses, my lord. For on what basis, my lord, the police investigated the matter and filed the search sheet, my lord.
That is, I am not on that, my lord, on the merit, my lord. My contention is that, my lord, as, my lord, there are, my lord, similar judgment is there, my lord. In similar cases, this honorable court has passed the order, my lord. The law of parity, my lord.
Heard Mr. S. Ahmed, the learned counsel for the petitioner. You also heard Mr. R.J. Borwa, the learned additional PP, appearing on behalf of state respondent number 1, NMS M. Khatun, appearing for the respondent number 2 and 3, that is the informant of the parents of the deceased. Who is the informant? Number 2.
Number 2, my lord.
And who is 3, in fact?
Three, my lord, one of the, my lord, mother of the deceased, my lord, another deceased, my lord.
Two persons died.
Two persons died, my lord.
No, why I'm asking, Nur Muhammad, son of Sagar Ali, that is the informant or father of the deceased.
Yes, my lord.
And number 3 is some Anwara Khatun. And he is the son of Abdul Hussein. Hussein.
Mother of Abu Talib.
I don't know, son of Abul Hussein. Her identity is son of Abul Hussein. Whether she is wife of number 2.
Wife of, my lord.
Wife of number 2.
No, my lord. That was, my lord, typographical mistake. My lord. Anwara Khatun, wife of Abul Hussein. That should be
Who is
wife
Abul
of,
Hussein?
my lord. Anwara Khatun is the, my lord, Anwara Khatun is the, my lord, mother of the deceased.
And who is informant?
Informant is the, my lord, respondent number 2, Nur Muhammad.
Now, who is he?
Nur Muhammad is the, my lord, father of one of the deceased person, my lord.
Or 2 different boys?
A different person.
Oh, I know. Initially, you submitted that 2 boys of respondent number 2, 3 died. I thought that they are parents.
Two different persons died, my lord.
Anwara is not the informant.
No, my lord.
One of the mother of one of the deceased. Respondent number 2 and 3 is our key level. This is an application under section so and so in connection with so and so. It is submitted by Mr. Ahmed, the learned counsel for the petitioner, that an accident took place and 2 persons died in the said accident, which is an admitted fact, and on the basis of which an FIR was lodged by the respondent number 2, who is the father of the one of the deceased, and the respondent number 3 is the mother of the another deceased. However, immediately after lodging of the FIR, both the parties had arrived into a settlement, and they also filed an application before the before the investigating officer to withdraw the case. But their prayer was not considered, and the case was accordingly investigated, and finally charge sheet was filed against the respondent petitioner number 1 petitioner. But the petitioners, but the respondents have no grievances against the petitioner, and as the matter has already been settled, hence there's no probability of adducing any evidence against the respondent petitioner, even if the case is allowed to be proceeded. Full stop. As the matter has already been settled, there is very remote, the conviction of the so-and-so is very remote and liquid. He further submitted that as there is no probability of, as there is abuse of process of law, and accordingly submitted, this is a fit case wherein the petition, wherein the proceedings can be set aside and paused by invoking the power under section 482 CRPC. In support of his submission, he also relied on the decision of the order passed in 3 criminal petitions, namely criminal petition number 9596 of 2019, criminal petition 992 of 2023, and criminal petition number 310 of 2024, passed by this court, wherein the similar kind of cases are being set aside and paused on the basis of settlement between the parties. Next para. Mr. Burwa, the learned additional PP, submitted in this regard that 2 persons died in a case, and the present 2 respondents are not the eyewitnesses to the case and quick case, and hence they look at the eyewitness of the case. The matter is the rash and negligent driving of the petitioner is a matter of trial, and that may be decided by the learned trial court below only after a recording of the evidences of eyewitness and other witnesses.
Since, my lord, they are not the eyewitnesses, my lord.
They are not the
So, my lord,
eyewitnesses.
They cannot say, my lord, their ultimate conviction is very much bleak, my lord.
Yes, so it cannot be said that by the respondent number 2 and 3 that chances of conviction is very remote and bleak unless without recording the evidence of the eyewitnesses. Accordingly, he raised objection and submitted that this is not a fit case to set aside and quash the proceeding by invoking power under section 482 CRPC. Next para, MS Khatun, the learned counsel appearing for the respondent number 2 and 3, submitted that the matter has already been settled between the parties soon after the lodging of the FIR, and respondent number 2 and 3, who lost their sons in the said accident, have no grievances against the petitioner, and accordingly she submitted that the respondents number 2 and 3 has no objection if the criminal proceeding is set aside and paused on the basis of the settlement between the parties. It apni hearing heri kore dibo. Hetu sing logai dibo. Narendra Singh logaba paribo. Lakshmi Narayan sai lobo logaba paine. Narendra Singh aru logai Gyan Singh or main portion logai dile. So if it is not probably of the conviction, then it can be squashed. Okay, your petition is allowed.
Obliged, much obliged. Obliged.
Okay, to থাকি যাব আর rest to থাকি যাব আর when not common. There are some more matters in the admissions column. Date will be there. Orders are also there.
Item number 30 as regards Jimma petition, my lord. Item number 30.
30.
Yes, my lord. Relating to, my lord, Jimma of a vehicle seized in connection with a NDPS case. In this case, my lord, I have instruction that charge sheet has already been filed and the owner has not been, my lord, capacited. So they may get the instruction and may be taken up on Friday, my lord.
Friday, we don't have time. Huh?
Next week, man.
Next week means 1, 2, 3, 31st. Lots of matters have been fixed, in fact.
Friday, this Friday.
This Friday, a small matter.
No, maybe if small matter for you, it had to reach, no? That's why. Already fixed matters are there. Searching the only left upper matters may be taken up after 2 weeks. Otherwise, it will be very probably because prior Bihu, there are lots of matters have been fixed.
Item 27, criminal appeal, madam, against conviction. May I pray that we take it up on Thursday, the hearing day.
Not possible. Hearing day.
On the hearing day,
It may not reach also. In hearing day, you want to fix it on admission column.
On Thursday, ma'am.
I don't think it will be. It will reach.
Attempt may be made, madam.
Because we see now prior Eid and prior Bihu, there are lots of matters have been fixed. Because maximum prayer from the council are there that is to be fixed before prior Bihu. Also, I mean prior Bihu as well as prior Eid. Your petition is how long in conviction? It is a case of criminal 25 only. Your petitioner is behind the, your appellant is, since when he is in custody?
Since 25th of February, my case, madam.
25th of February, 2025. It will come after 2 weeks only. There are cases, I mean, how 2 years, 3 years are also pending.
My lord, item 42, my lord. My lord, this is a condemnation petition, my lord. in a criminal revision petition.
Condonation was there.
Yes, my lord. Delay is there.
42.
Yes.
42, okay, we
Taken
are
up it
listing.
on Friday, my lord.
Friday, I don't know. Friday, Friday is what? It is not more Saturday, I think. Okay, then we are fixing it as a short matter. We're fixing it.
Lordship, item number 51. Lordship.
Rest, we will fix it after the leftover matter. After 2 weeks.
Lordship, just small prayer, Lordship. Item number 51, Lordship. Lordship was directed us to file one additional affidavit, Lordship. It was again.
It was in the morning at hours. It is said if affidavit you have filed.
File, Lordship. Only NBW issue, Lord. Only NBW issue, Lordship. That day, even Lordship was supposed to dispose of the matter, Lordship, by verifying whether I was regular or not, Lordship. So I was very much regular, Lordship. That day, even I was making submission, and even in this additional affidavit also, it can be seen, Lordship.
First of April. 1st of April. 1st of April, you are listing.
In item number 20.
Item number 51, 1st of April.
Lordship, in item number 23, any date may be given, but LCR may be called for your lordship.
23.
23, your lordship, the person is behind the bar since 2 years. So if LCR comes up any day, I will be able to argue on the matter.
LCR was not called for.
No, LCR was not. It's the first date when it was listed for admission. Today is the first date, your lordship.
23.
23, your lordship.
23 list of the matters will be left over because we don't have time. Sorry.